and the person that is going to give us the presentation. But members, I just forgot something very, very, very wonderful that happened in this committee. We are blessed as this committee that 2 of our members are being promoted into the executive. That is Honorable Pravin Gordhan as the Minister of this Portfolio Committee, Public Enterprises, and Honorable Mondli Gungubele as the Deputy Minister of Finance. I think we should be proud as this committee to have served with people like them, men with credibility. May the dear Lord guide them in their new endeavors. I would have been punished by this committee if I haven't done that. I know that they were very useful in the committee. They were members that took this inquiry very seriously. We will always miss them, but because we are going to meet them in the corridors, we will always interact with them, and we will always, if we want any guidance or any suggestion, we will always talk to them. But now I want to welcome Mr. I don't want to pronounce the name wrongly. Let me look at it. Raji Murugan, who is going to give us the presentation. Before that, he is going to take an oath. You have the 2-page up in front of you. Thank you very much. Let us then read the oath. In accordance with Section 16 of the Powers, Privilege and Immunities of Parliament and Provincial Legislature Act 2004, as a witness to this oversight inquiry, please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry. Notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath before a house or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privilege and Immunities of Parliament and Provincial Legislature Act, a person who willfully furnishes a house or committee with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are then required to take the oath, and you raise your right hand.
Madam Chair, I, Raji Murugan, swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. I hope people who are listening are internalizing the oath, and those who came before you are also starting to internalize what is it to take an oath in Parliament or in a place where an oath is taken, even if it's in front of a church minister. What does the oath mean? Thank you very much, Mr. Murugan. Then I will give over to you to present to us what you have in front of you.
Honorable Chairperson, honorable members, Advocate Vanara, and all those present today. Good morning. G9 Forensic is deeply honored and massively relieved that together with Senior Counsel Dumis Nsebeza, my colleagues Mrs. Jeanette Ace and Mr. Sipiwe Nkomo, that we are finally able to provide this committee with a different version, probably for the first time, an insider account of how the Trillian investigation came about, where it is, and where it needs to be. We begin with a letter that we wrote to the Portfolio Committee.
Oh, could you please speak to the mic
Okay.
so that you get recorded?
My apologies.
Thank you.
We begin with a letter that we wrote to the Portfolio Committee addressed to the Honorable Committee and copied to the interim group chairperson, executive of Eskom, and the head of forensic, Ms. Tembeka Ndaba. And please allow me, Madam Chair, to just go through the letter, because I think it gives an overview and an understanding to yourselves in terms of what actually transpired with the start and very quick termination of our investigation. And the communication reads as such. Dear Honorable Chairperson, this communication to the Honorable Committee members reflects the views of G9 and is intended to set the record straight in respect of its own investigations and services to Eskom. It does not and is not intended to represent the views or position of Eskom Holdings, SOC. G9 Forensic was appointed by Eskom's Anti-Corruption and Forensic Department, led by Mr. Tembeka Ndaba, to investigate anonymous allegations of possible irregular payments made to Trillian. We have since submitted a detailed report setting out our factual findings, albeit with investigations left outstanding for reasons explained below. It has come to our attention and subsequently verified by us that on the 23rd of January 2018, Mr. Anuj Singh, during his testimony to the committee, stated under oath, in cross-examination by the Honorable Swart, that G9 had withdrawn its Trillian report. This is not true, is inaccurate, misleading, and a fabrication. We wish to clarify and confirm that G9 has provided a substantive and comprehensive report to Eskom on the outcome of its investigations. Even though the investigation was prematurely terminated by the former board or individuals on the board, its content, factual findings, conclusions, and recommendations are definitive and sustainable in as far as the veracity of the allegations and the evidence gathered. G9 has had no reason to withdraw its report, which is both compelling and convincing in both identifying administrative misconduct and criminal suspicion, which requires investigation by a competent law enforcement agency without any further delay. It may come as no surprise to the Honorable Committee that the former board, specifically the former chairman, Mr. Zatemba Khoza, vigorously and deliberately stifled the Trillian investigation being conducted by ourselves. He, acting alone or with others on the board, subjugated the investigation, suggesting that it was baseless, without merit, or ill-conceived, according to anonymous but credible information. We wish to place on record that such sinister conduct was not only a derogation of his and or former board fiduciary obligations, inter alia in respect of the Trillian investigation, but it was an intentional and direct attempt to mislead Parliament, its shareholders, and the country. On the 30th of August 2017, G9 presented the progress of the investigation to the Audit and Risk Committee, which incidentally was made up of the full board, or the interim board at that stage. I think there were about 6 members. We were mere 6 weeks into the investigation, making good progress and exposing significant excesses, misconduct, potential contraventions of the PFMA, and exposing possible criminal conduct by certain individuals and entities. The former board resolved in our presence that G9 was to interview McKinsey and Trillian officials, including Mr. Anuj Singh, and several other witnesses those against whom allegations were made. To our utter amazement and chagrin, the board reversed that decision within 2 hours of G9 leaving that meeting and instructed that no more investigations be conducted by G9 and that we were to provide a final report. We complied and provided a report of our factual findings up to the point while in the media, including through the testimony of Mr. Zetemba Khoza to the committee, it was being suggested that investigations in respect of Trillian was continuing. It was stopped or terminated on the 30th of August 2017. G9 respects the right of Eskom to take decisions to initiate or terminate investigations. However, persistently misleading the public and government up to the point of the appointment of the newest board and acting in a manner which potentially covers up corruption can only be described as callous, if not criminal. The former board, by its actions or omissions, together with the utterances of Mr. Anoj Singh, seeks to undermine our investigations and report. They cannot be allowed to. The information and evidence of wrongdoing elucidated in our report is supported by the evidence of many, in no small measure through the work of the committee, not to mention several investigative journalists and media houses and the evidence uncovered by them. We would respectfully submit our report with Eskom's approval to be tested in any appropriate court of law and allow our honorable courts to become the final arbiter. In closing, the former IGC, Mr. Johnny Dladla, and Eskom's anti-corruption forensic department have been highly proactive and supportive to this Trillian investigation. They spearheaded our work through their oversight of our investigations and with their active professional support with a vigor and determination seldom seen in the public sector. They cannot or should not be painted with the same dirty brush as some or one in the former board and those implicated in wrongdoing. We respectfully submit, and we believe that it is our duty to point this out to the committee today. We would sincerely appreciate a public rectification of any untruth about G9's report, and I close by saying, should you require any further information, kindly contact Eskom directly. Signed by myself. Honorable Chairperson, or Madam Chair, and honorable members, we respectfully suggest that our presentation today should proceed in the following manner. This opening high-level account is meant to provide the committee, and indeed the country, with the facts on how our appointment and the early termination of the investigation and all the events in between. We believe that this is necessary to provide the clearest picture of what has transpired in this Trillian investigation. We shall further present the report as long as you allow us to. In the process, we shall, where we deem it necessary, provide an overview of the documentary evidence, portions of affidavits, audio recordings, and pull all of these together to inform the committee on where there is suspected criminality or patent contravention of Eskom policies and procedures, as well as national legislation, which includes the PFMA. G9 was appointed by Eskom's anti-corruption unit, as I said earlier, and I'm going to move on. At an early juncture, allow me, without sounding patronizing, to record that Eskom's internal audit and forensic department must be credited and commended again for their support. I'm going to just move on to the next paragraph. This investigation lasted all but 6 weeks, as I said. In our respectful view, we are making significant progress, uncovering contraventions of the PFMA and the legislation. Very quickly, the body of information and evidence pointed towards possible corruption, money laundering, and racketeering, as you will see in our presentation of the report. While the obvious names, the much publicized names, were becoming clearer on our radar, many questions remain in respect of who the others are. This can only be revealed if the investigation is allowed to recommence and is to be brought to its natural conclusion. Just to highlight, Madam Chair and honorable members, after about 3 or 4 weeks, and I'm trying to give you a timeline, After about 3 to 4 weeks of our investigation, we met with the acting IGC, Mr. Johnny Ladla, a man who we have high regard for. We say this because he was fully behind this investigation and provided us with all the required support and mandate. Maybe too much for the good of Eskom and himself. It is clear in our mind that this is one of the most critical factors that led to him being removed from that post. Our credible information is that the management of the investigation was taken away from him by the former chairperson, Mr. Zatemba Khoza, to be overseen by himself and the interim board. This, honorable members, is highly unusual, or in fact contrary to any or all governance protocols. Put simply, the results and confirmation of unbridled abuse and dodgy decisions in the Trillian investigation, which involved some of the former board, previous chief executives, and some executive managers at Eskom, was not palatable for Mr. Khoza. Why this was so is a matter of conjecture at this stage, but we are prepared to fearlessly venture or volunteer a few reasons. Number one, he is possibly involved in the Trillian debacle by association. Number two, he was derelict in his duties as the chairperson of the board tender committee, which approved this tenuous contract with McKinsey. Our investigations incidentally confirmed that there was no contract with Trillian. Now that obviously is not even a revelation to yourselves anymore. We were called to present our summary findings to Mr. Ladla, and about 2 weeks later we were requested to present to the Audit and Risk Committee, as reflected below. I've covered that in the letter, so I'm not going to belabor that point. If you could go to the last paragraph on page 4. At that meeting, it was resolved that the investigation should continue and the G9 should interview McKinsey and Trillian, as I said earlier. Okay, I'm going to jump to the last paragraph of that page because it's been covered in my earlier statement. In hindsight, I probably should not have informed the board that they were potentially guilty of contravening their fiduciary duties, and that as a forensic firm, we had no intention to leave them out of the equation. My exact words to Mr. Zatemba Khoza was that we would investigate the BTC decisions and that I can assure them that we would not gloss over the conduct of the BTC. You see, honorable members, this Trillian mess, in our view, must be left squarely at the door of the previous board tender committee, as we will discuss later, and includes several entities and officials, as will be seen from our report. We proceeded to write the report, and we've given them a report in September 2017, a report which is substantially similar to the one that we present to you today. We believe that the report that was provided to the Portfolio Committee may well have been a 21-page summary report by G9. This is what we believe represents the leaked summary report which has been quoted in the media. We believe that our mandate was terminated because we made clear intentions to investigate the BTC. We understand that Mr. Khoza informed the committee that Bowman's and G9 reports were taken on review. We sit here today deep in the knowledge and hope that it's time for those that have brought us to our knees with corruption shall now face the full might of the law. We stand ready to investigate fairly, transparently, and vigorously to ensure that anyone who may be guilty is finally arrested and charged. In closing, we can confirm that G9 has provided an affidavit to the Hawks on the instructions of the new IGCE, the head of forensic, to institute criminal investigations against anyone involved, inside or outside of Eskom. In respect of this Trillian report, I have submitted an affidavit to the Hawks and can confirm that G9 will assist the Hawks during their investigations, and further discussions with Eskom shall take place on this matter going forward. I would now take the remaining time to reference our report in terms of our findings, conclusions, and recommendations. Madam Chair, honorable members, I now refer you to our report. Madam Chair, in the time that we have, we will try our best to set a very high-level account of what our report says. As you would see, we wouldn't be able to get through the entire report, and we would leave that at your own leisure to read and make your own minds up in terms of the pieces of evidence that exist. If I could take the Honourable Chair, the Advocate Vanara, and honourable members to page 8 of the report.
Sorry, Mr. Morogwand, that I would appreciate because as you have already said, the report is thick. Every time you get into a page, refer us to that page. You mention the page and then we get into that page, all of us get into that page at the same time. Thank you.
Thank you, Madam Chair. Madam Chair, honourable members, page 8 sets out the scope of work that was allocated to G9 Forensic. Now, just for the record, G9 Forensic is one of many companies that are listed on the panel of service providers at Eskom's Anti-Corruption and Forensic Department. The first paragraph, the scope of work and the approach for this assignment are outlined below. And it was to investigate allegations of inter alia, financial and procurement irregularities against senior officials or any other person who may have contravened policies, procedures, or governance protocols, including legislation, in their actions and or omissions in respect of Trillian contracts and payments. This stems out of an anonymous complaint that, and this came from a whistleblower that said, and I'm going to read it so it's clear right at the outset. A supplier known as Trillian submitted an invoice which was paid within one day and not 30 days. The complainant wishes to know how an invoice could be paid within 1 day and not 30. The complainant states that the procurement department did not follow the right procedure to pay the invoice. The complainant stated that the contract number is 4600061892. Purchase order is 4502469222. Invoice document in SAP is 5180439916, and the supplier vendor code is 11083725. The complainant stated that the invoice before VAT is 134 million, and with VAT included, the amount was paid 152.6 million. I nearly said listen properly. And that the invoice was for management consulting services for an Eskom initiative. The complainant stated that on the document, the invoice was loaded on instruction from Mr. Charles Kalima, a senior procurement manager, and that Mr. Edwin Mabalana is also involved and that he is an executive manager. The complainant further stated that the information given here is all they have because this was sent by mistake and that they do not know who paid the invoice and by which department it was made to. So that, Madam Chair and honourable members, sets out what we were meant to be doing at Eskom. Madam Chair, I'll take the committee to page 13. Under paragraph 4.3, staff cooperation, the second paragraph, that some of the members of staff were being calculatedly evasive or self-preserving in their responses. This included those in the most senior decision-making positions or committees. We found that those at middle management to lower levels were more cooperative and forthcoming with the information requested. Ma'am, as you would understand, I am actually going through paragraphs that I think would give an understanding of the report. We wouldn't be able to cover it if I went slower than that. But if you wish for us to do so, we can do so. I take you to page 16, paragraph 5. And I'd like to inform the committee that the methodology that we used, as with any other forensic firm that would use or investigative bodies, was to obviously look at the interviewing witnesses, interviewing those against whom allegations were made, reviewing and analyzing documentation, legislation, policies and procedures. And one of the most critical things that we looked at in the report, in our investigation process, is the Constitution of the Republic of South Africa, specifically Section 217(1). And we used all of these pieces of legislation and policies to look at the conduct of everybody involved and whether they fell short of legislation and policies and procedures. Now, Section 217(1), I don't need to tell you because it's you yourselves that have given us the Constitution and our laws. Section 217(1) requires all organs of state in the national, provincial, and local spheres of government or any other institution identified in national legislation to inter alia contract for goods and services in accordance with the system which is fair, equitable, transparent, competitive, and cost-effective. And I highlight this, Madam Chair, because we will show in this report that from Section 217 of the Constitution right through to most national legislation and policies of procedures, these were all totally disregarded and ignored. Page 17, Madam Chair, honorable members, talks about the Public Finance Management Act, and you know it, so you would know yourselves, what the burden that rests on any employee of state. So I will not pay much attention to that today. I take you to page 21, paragraph 7. And this is an important piece of Eskom policy that deals with the procurement policy within Eskom. And the procurement policy number is 321034. So everything that any member of Eskom was called to do in relation to contracting with McKinsey and or Trillian or any other service provider or supplier must be done in accordance with this policy, which is listed in our report from page 21. I'm going to take you to page 28, our factual findings. Paragraph 8, subheading 8, I take you to the third paragraph, and we say, although we are satisfied that the investigation can authoritatively and substantively arrive at findings, conclusions, and recommendations which can be acted upon internally, the allegations and widespread reporting which points to possible criminal conduct by individuals and or companies was not fully or satisfactorily investigated by G9, again, through no clear mandate and the support of the interim board. On page 29, Madam Chair, paragraph 9, one of the methodologies that we adopted was that we looked at evidence that already existed in the public domain. And you would know that the state of capture report was one of the substantive pieces of reports or evidence that showed where we were in terms of the suspicion and, of course, actual state in relation to corruption. So we took Advocate Trillian Madansela's report. We looked at those portions that were relevant to Trillian, and we incorporated it into our findings. And one of the areas that we concentrated on, as far as the report is a state of capture report is concerned, is on page 30. But sorry, Madam Chair, I'll take you to 29, the last paragraph. Several Trillian associated companies and their respective shareholdings are set out in the report. Of interest to this investigation and the Trillian transactions at Eskom are companies which are said to have contributed to the purchase of Optimum Coal. And they are inter alia, Trillian Capital Partners, Regiments Capital, and Albertime. The relevance of this is that Trillian is 100% owned by Trillian Capital Partners, which in turn is allegedly owned by Mr. Salim Essa. We quote paragraph 5308 of the State of Capture report with the heading Albertime. The following was found by the Public Protector investigation. As mentioned above, Mr. Mudley is the sole director of this entity and is a special advisor to the Minister of Mineral Resources. Mr. Mudley is married to an Eskom board member, Ms. Firoshni Naidu. Ms. Firoshni Naidu, in her declaration of interest to Eskom, dated the 19th of February 2016 and the 31st of May 2016, lists herself as an employee of Albertime, which obviously contributed to the purchase price of Optimum Coal. Now, the relevance of this to us was we were trying to determine if Ms. Firoshni Naidu was conflicted in having participated in board decisions to award this McKinsey/Trillian contract. Now, let me say that we have made no adverse finding against Ms. Firoshni Naidu at this stage because we didn't get that far in as far as the investigation is concerned. On page 31, paragraph 9.2, the Bartender report, we place significant weight on the Bartender report, and we say why in our report. The first paragraph, our investigation considered some of the findings of Advocate Bartender, SC. Our view is that his access to Trillian during his investigation, albeit limited, provides insight into what he had uncovered, and in some cases incontrovertible evidence. Of interest to us was the structure, shareholding, and directorships of Trillian, related entities, and the evidence covered by the Bartlender's report. In his findings, which we concede has not been ventilated in any legal forum, provides several pieces of evidence which was either corroborated by our own investigations or by documentation which was annexed to his report. I will move on to page 33. And I don't want to read that paragraph out of context, so we'll go back to 32. Page 8 of the Bartender report says, regrettably, Trillian management has not made good on any undertaking, and I guess it was undertaking to provide evidence to his work. Since January 2017, the Trillian management have consistently obstructed my attempt to conduct a proper investigation. They have refused, despite repeated requests and despite undertakings which they have given, to provide me with the documents and other information which are required in order to be able to carry out this investigation. We say that we believe that this is hardly a response that one would expect from Trillian. If it truly believed in and could substantiate the legitimacy of its business relationship with McKinsey and Eskom. This alleged failure to cooperate with an investigation initiated by its own board or chairperson is one which places significant currency on the assertions leveled against Trillian. that its Eskom business dealings were suspicious, non-contractual, and illegal. We move on, Madam Chair, honorable members. Yeah, on page 33, Madam Chair, Bartender confirmed that the CEO informed him that Trillian was involved in assisting Eskom with the Dover boiler claim, which we confirmed was embodied in one of Trillian's invoice, which is provided to Eskom. There is some suggestion that the CEO, probably Ms. Bianca Smith, and by implication Dr. Wood, were both providing these services on behalf of Regiment's Capital. This does not seem to be accurate or true if one believes the version of Mr. Niven Pillay, who is the CEO of Regiment's Capital. According to our investigations, Mr. Niven Pillay of Regiments and other information at our disposal, Regiments had no business relationship with McKinsey at Eskom at the time. This might be a matter of legal technicalities, but Trillian is standing on its own at Eskom when they are busy with the corporate plan work at Eskom from September 2015 until March 2016. Madam Chair, honorable members, this will become very clear as we go towards our conclusions and factual findings. Madam Chair, I take the committee to page 42. Madam Chair, what we would do is we will also elect, if you would allow us to provide you, to play to you very short audio clips of our interviews with Mr. Prish Govender, Mr. Charles Kalima, and Mr. Edwin Mabalane, to show this committee not only our views and the views of the witnesses and the evidence that we've obtained, but their responses to some very critical questions that you have been asking and we've been asking.
Madam, please, could you stop walking in front of the speaker? You are interrupting the proceedings of the committee.
Madam Chair, on page 42, on paragraph 10, we made a note of the legal...
Sorry, sir. Ms. Ace, can you switch off the mic in front?
Okay. Sorry, our apologies. Madam Chair, we speak a little bit of the legal opinion that was provided by Ledwaba and Mzwai. And it relates to two very critical portions of our investigation and questions that you've been asking in the past that relates to sole sourcing of McKinsey and the remuneration model that was applied to pay McKinsey. I'd like to say, Madam Chair, that the Ledwaba Mzwai legal opinion was not a legal opinion that was sought by Eskom. It was the legal opinion that was provided, from what we believe, by McKinsey to Eskom officials to support their position. And you would see in our report as we go along, when you read it at your own leisure, that these very senior Eskom officials, Mr. Prish Govender, Mr. Edwin Mabalane, Mr. Charles Kalima, and by direct implication the BTC and the board, placed more weight on the Ledwaba Mzwai legal opinion, which suggested that the remuneration model and sole sourcing model would not offend the PFMA or any legislation. And this went against paragraph 11, and you know that, a legal opinion provided by Advocate Paul Kennedy, SC. Madam Chair, would you allow us to play that little recording for you?
Did ask questions,
Yeah.
right? Because my questions was not around the process side. We had somebody that was accountable for the process, right? And that was the CPO. My understanding was, or my questions was, can the guys deliver in terms of our requirements as part of this contract?
No, Mr. Governor. I mean, you can ask me if I can deliver, I'll say yes. The issue is, the question that I was going to ask, 3 billion rand is potentially what it's going to cost Eskom to pay McKinsey after 3 years. Whether it comes through savings or some other fantastic formula, God only knows. But 3 billion rand. 30% of the 3 billion is what? 30% of a billion is 300. So it's about almost a billion itself that's going to go to this so-called BE partner. You don't take any care to call Trillian in, to call McKinsey in to say, we want to know before we agree or accept Trillian, what is your capacity, who you are, because Trillian from a financial...
But sir, let me correct you. I think the factual issue was, we had a number of steering committee meetings. In the steering committee meetings, we raised the concerns, and it's in the letter as well, around the capacitization development of the BE partner. That is one of the key concerns that we raised. Now, why I come back to the point of saying there was a clear intention from McKinsey to use Trillian? Because in the presentations that were afforded to us in the steering committee by McKinsey, they show us a clear plan which they worked jointly with Trillian on how this partner would be developed. So we did ask the questions because...
Madam Chair, would proceed. At least it gives you a flavor of something that's going to come later. It's not the exact one that we wanted to play. But be that as it may, we would move on to, on page 42 to number 11. Advocate Kennedy was briefed by Eskom through Nkunu attorneys. He was asked as counsel to determine whether the proposed fee structure between McKinsey and Eskom was lawful. The three subject matters were as follows. Supply Chain Management Practice Note number 3 of 2003. On the next page, the National Treasury Instruction of 2013-2014 Cost Containment Measures and Guidelines on Cost Containment Measures issued by the Office of the Accountant General. The opinion issued by Kennedy is listed below. There is doubt as to whether National Treasury Practice Note number SCM 3 of 2003 has been repealed expressly. The practice note has at least impliedly been repealed and been superseded by the instruction. One course, at least in theory, available to Eskom is to negotiate with McKinsey and to pay remuneration in accordance with those prescribed, typically hourly rates. And if, however, that is not an option, it would be possible and advisable for Eskom to apply for a deviation from clause 4.2 of the instruction so as to permit the sort of remuneration model being negotiated with McKinsey. In a nutshell, Kennedy advised Eskom, specifically Mr. Mabelane, Mr. Prish Govender, and by extension Mr. Anod Singh, that the remuneration model would offend the Treasury instruction. Although we have not received the version of Mr. Singh, it is evident that these requirements and discussions were brought to his attention. Mr. Mabelane signed a letter of acceptance with McKinsey on the 17th of December 2015. 2 weeks after receiving Kennedy's opinion, which says, you are going to offend, he goes and signs the letter of acceptance with McKinsey. We would have found that, and by allowing this legal opinion by senior counsel to be superseded by signing the notification of acceptance, that he was potentially exposing himself and Eskom to be guilty of fruitless and wasteful expenditure in terms of Section 45C of the PFMA. We say this conduct is irregular. Further, in signing the offer letter, he, meaning Mr. Mabelane, bound Eskom to a contract which was in contravention of the PFMA and other internal policies. We have not been provided with any documentations or minutes from the SteerCo which authorized such acceptance to take place. Although the BTC delegated the authority to the Chief Procurement Officer, one would assume that acceptance and final approval would come out of the SteerCo. It cannot or could not, in our view, have come out of the negotiation team. This is a clear indicator, as suggested elsewhere in our report, that the necessary legal and financial approvals within Eskom had not been diligently sought, assessed, or applied. Or if they were, these other officials' views did not count for much or were patently ignored. Madam Chair, we then take you to paragraph 12, page 44, and this part of our report deals with consultations, mainly with Eskom employees and other witnesses. For the purposes of protecting these employees, in many instances, I'm not going to mention the names. The names are in front of you. And where I feel that we are comfortable and the witnesses are comfortable, we'll do so. The person listed in 12.1 was a commodity manager for professional services at the time that McKinsey was contracted on the MSA project. Now she says, in a sworn affidavit in our possession, that she provided an overview in an affidavit of the procurement process which should be followed. The extract below is from a statement. And it's quite long, so I'm not going to belabor it. You will see it. But the gist of the matter is that she set out basically the path that need to be followed from inception until contractual stages, which she is an integral part of, being the commodity manager for professional services. And basically what she says in a statement, we'll go back to page 46. After giving us a rundown in terms of all of the hurdles or burdens that needed to be set aside in terms of policy, she also further indicated that she was a custodian of the master file. And I'm talking about the MSA contract between McKinsey and Eskom. And as such, all transactions, the legal documentation and submission documents should be in this file. However, this is not the case. Even in asking several senior officials for the signed copy of the service level agreement, this was not forthcoming. This is her statement. When she was informed by us that we had seen a signed copy, she was surprised that one existed. According to her, the unsigned copy was what she has in her file, and this was utilized for payments and other purposes for the entire project to both McKinsey and Trillian. The lady concerned has provided us with several addendums which are appended to affidavit. These will be analyzed later in the documentation review section of this report. The second witness on page 47, 12.2, is an assistant buyer, also made an affidavit to us. What this witness says is that on the 12th of August 2016, the witness was at the desk when a discussion took place between an assistant general manager and his immediate superior. The manager indicated that there was a need for a purchase order to be created on the system, which were payments for Trillian. Now it's only at that level that purchase orders can be created. Now, as much as many of these individuals that we speak of today had significant power, there were certain things procedurally that they couldn't do. So obviously, what gets done is that you would pressurize those that are below you and ensure that things are done that should not be done. At the time, this acting general manager provided 2 invoices and no supporting documentation. According to the witness, there were lengthy discussions about it because it was not procedural in terms of payment policies. This witness requested the documentation from the acting general manager and his supervisor, and that was never forthcoming. During the next few days, because the documentation was never there to support those purchase orders to be created, to ultimately pay Trillian, this witness requested from his seniors several times for the supporting documentation, which authorizes the purchase orders to be created. The witness believes that those superiors also did not act regularly. Some of the salient parts of the invoice, the affidavit which goes on to page 48 says, and I'm going to leave the name out again, although the request by the witness was not, although the request by the senior was not procedural or the norm, I proceeded to create the order based on the instructions given to me, despite the lack of supporting documentation. The purchase order and the numbers given was created on the same day by myself, and an email was sent to those superiors who had requested that he create those purchase orders. The witness says that he requested for the supporting documentations in the days and weeks subsequently. The documents arrived a few days later. Upon receipt of the supporting documentation, particularly the service level agreement, the submission to the BTC, the minutes of the steering committee meeting on the top engineers program, I later noticed that the SLA and the minutes were not signed. This is a feature, Honorable Madam Chair and Honorable Members, throughout this investigation. Nothing is signed, or if it's never signed, it's just incomplete documentation. Totally against PFMA, totally against all relevant Eskom policies. The witness says on the 4th of July 2016, an email was sent by the acting general manager to himself. The subject line indicated the purchase order number and purchase order was attached. The witness stated in the email, "Good day, please find the only communication for the Trillian transaction. I am sorry, but it seems it was verbal instructions." The witness, "Do you have any prior communications and instructions in this regard?" So he's continuing to query this illegal and irregular transaction. So he writes to the superior and says, "Here is the purchase order created as per your request. We will need the following documents for our file to be completed. Full report that was presented to the board procurement tender committee, we received an executive summary so far. The main issue is that the report does not indicate the link of Trillian Management Consulting to McKinsey and Company." And he lists out in his affidavit what was required to legalize those purchase orders being created. And you can read it for yourself. It's proof of board approval by means of extract of minutes, proof that funds from finance or what was presented to the board procurement tender committee being available, signed SLA and the like. So none of these which should have been available by policy and procedures and by law were available or provided to him. On 12.3, page 50, this witness has confirmed what the previous witness had said, as he is the superior or senior manager of that department. On page 51, 12.4, this was the acting general manager at the time. This is very important, Honorable Committee. The witness confirmed that she gave the instructions to the two junior employees. The witness states that she was under intense pressure from Mr. Edward Mabalane. She conceded that the documentation for the loading of the two invoices were incomplete or not available. And in the extract of her statement, I realized at the time that the creation of the purchase order was irregular and against policies and procedures. It concerned me, and afterwards I contacted Mr. Govender as the project leader in an effort to obtain further supporting documentation. He said it was a procurement matter and I should not be concerned. I also discussed it on more than one occasion with Mr. Mabelane and aired my concerns. He said, we have all the documentation and the transaction is above board. Next paragraph. At a later stage, Mr. Mabelane contacted me again and requested me to create a purchase order for another invoice from Trillian for about 134 million. This time, I refused to do it and said he can contact my colleague, Mr. Charles Kalima, General Manager, Commodity Sourcing, Acting. The first two invoices should also have been created by Mr. Kalima and his team. Next page, page 52, right at the top. I am of the opinion that Mr. Mabelane and the team who negotiated the terms with McKinsey should be held accountable. In hindsight, I wish I acted bolder on that day in August and refused to create the purchase order. On page 52, Madam Chair, Honorable Committee members, is a witness who created that illegal contract on the system, the SAP system for Trillian. And the witness says this much. She confirmed that on the 19th of December 2016, Mr. Charles Kalima, but before I go there, Madam Chair, and I think you would have those facts or you would have heard it before, you would know that there were several payments to Trillian prior to this December payment. So this directly shows and suggests that those payments were made without a contract to Trillian, because they're creating a contract on the SAP system in December 2016, either fraudulently or irregularly. The witness confirms that on the 19th of December 2016, Mr. Charles Kalima came to her and provided her with a board submission document and board minutes to create a contract on the SAP system. She indicated that this was not the norm. He stated to her that the contract must be created in favor of Trillian, although the supporting documentation was not clear to her in terms of who Trillian was and what it was doing. The submission only referred to McKinsey's broad-based black economic empowerment partner. She complied with that request from her general manager. The extract of the affidavit says, according to the date on SAP, on the 19th of December 2016, Mr. Charles Kalima approached me and requested to create a contract on SAP. Mr. Kalima told me the supplier is Trillian, gave me the term of the contract. I did not receive a contract document, but was given the approved board minutes and a submission at the annexures there by Mr. Kalima. As far as I remember, the submission referred to the McKinsey BEE partner. She confirmed that she made a note on the system that she was requested by Mr. Kalima to create the contract. And this was really an exercise that she had done to protect herself, that if there was an order down the line, that it would be remembered and shown who gave that unlawful or illegal instruction. On page 53, 12.6, Neo Solanko. Mr. Solanko was interviewed telephonically on 2 occasions. He is the former general manager of Eskom Legal. He confirmed to us that he was called in on that MSA project towards the end of the negotiations to provide legal opinion on the remuneration model, sole sourcing, and to approve the SLA. He stated that he had on numerous occasions warned Edwin Mabelane and Prish Govender that the remuneration model was not consistent with law. These gentlemen sought external legal opinion, which was also consistent with Eskom legal department's views. Mr. Solanko confirmed to us that he did not approve the SLA, which was a McKinsey drafted document. Although Mr. Prish Govender brought the file to him for approval, he had not approved or aligned legal with the position which the senior officials who were dealing with this MSA project. We were still in the process of commissioning his affidavit. So the gist of the head of legal at Eskom at the time says that I did not agree that the McKinsey contract in and of itself was a legal, prescribed to the legal requirements. Madam Chair, if you'd allow me, we would play you a clip in relation to that contract.
Decision on, I would not have been party to it if I knew that this thing was from the initial wrong and dirty. I would not have been party to this transaction if I knew that, some of the things I found out now about the triple BEE of Trillian that you showed me, which I did not. All of us went into this transaction knowing that we're doing the right thing. It would have been...
You could not have known because you never asked the right questions. In terms of the SDNR partner.
Yeah, we can come to that.
Okay.
But what I'm trying to say to you is that when we went into these motivating forces, I personally went to National Treasury to go and ask them if we can do a risk-based contract.
And what did they say?
Risk-based contracts were allowed.
Is that in a meeting or did they give you a...
In a meeting, but they also sent us an email, which I think you have interviewed one of my colleagues who may have shown you that email.
Is that email sufficient for you, as senior as you are, for you to accept that that is approval from National Treasury? You want me to read it?
It is not. No, I did not seek approval. All I'm saying, what we were asking for is practice note 3. Is it still valid or not?
Yes.
Practice note talks about contingency or risk-based types of contract. Because the confusion that was there from the different legal minds, one of them says, no, you cannot use it. Then the other one says, yes, you can.
Who is the other one that said, yes, you can use it?
No, now you're asking.
Ledwaba Mzwai.
You should have that.
Yeah, Ledwaba Mzwai. But you didn't get them.
Sorry?
You didn't get Ledwaba Mzwai to give you that advice. It was McKinsey.
Yes, I know. Ours said we could not use it. And the risk-based approach is something that we believe can add value for the organization.
We don't dispute that, sir.
Yeah. So what I'm saying to you is that I'm probably going off my tangent, but what I'm saying to you is that we could not have gone into a sole source agreement with McKinsey if we did not believe that they had unique capability to deliver on the top consulting program.
But within a month or two of getting into the contract, in your steer course, you guys are not believing in sole source anymore. I mean, we can hear you guys talking on the tapes. You can see to the minutes that the Treasury is not happy with the sole source arrangements. There's a lot of buzzing in the corridors. Is that correct?
Yeah.
Yeah. So if you are so convinced that... Madam Chair, we'll just play you another short clip that relates to Trillian and its SDNL status at Eskom.
In fact, more so for the lead partner. So to McKinsey, and that's probably the reason why they would want to bring in a black partner as their...
Yeah, but I mean, it's from what we know,
Yeah.
McKinsey need not bring anybody. They are 135%. They contribute 1. So there's absolutely no reason for them to bring a black. Not really. Okay.
There's something else that we're driving within this organization. It's called, other than the triple BEE level, we're driving transformation. So we're trying to encourage black ownership of organizations. You could be a level 2 for all I care, but you don't have a single black person owning or controlling shares within that organization. And for us, that is critical.
It's critical.
Yeah.
Can I tell you something that the documents show?
Yes, sir.
Trillian has got 0% black ownership.
Really?
So
And the lady?
Pardon?
And the black lady? My pen has stopped working.
Can you, have you got the vendor document for Trillian? Let's talk a little bit about this is a document that's provided by Trillian to be on the vendor database.
Is an affidavit.
Can you see the highlight in green?
Yeah, 00.
So you, Mr. Karima, you are punting Trillian being black, Trillian, obviously getting upskilled. How black is that to you now?
My goodness. This is terrible.
Okay, let me ask you.
Really?
It's signed by the CFO of Trillian.
I see that. This one?
Yeah.
The CFO. Okay.
So basically, if I may put it a little bit crudely, the position that you were taking is blown out of the water with that document.
Of ownership, yes.
Of whether Trillian...
So they're not even a BE partner.
According to their own documents, not my document. So if you are part of a steering committee and you allow this to happen, either because you don't do the proper due diligence or you don't ask the proper questions, to what extent are you complicit in this finding, assuming that it is fact?
That is a shocker.
Is it a shocker?
Because as far as I know, including up to now, I find it very difficult to believe that they were 0%. The whole period that Trillian was introduced to us, they were introduced to us as a triple BE partner.
Madam Chair, that clip would, I hope, give the committee a clearer picture in terms of Trillian, which was brought into that MSA McKinsey project because it was a supply development partner. That probably shows the level of misrepresentation, not only by Trillian, which constitutes fraud in our opinion, but also by the conduct of McKinsey and its directors. On page 53, 12.7, this witness, Mr. Aziz Laher, is the group compliance manager and a PFMA specialist. He confirmed that he provided advice to Mr. Edwin Mabelane, Mr. Prish Kavand, and Mr. Anod Singh, either in emails or during formal and informal conversations, that the MSA project could not or should not proceed without National Treasury approval in respect of the deviation on the remuneration model for the contract. In the last paragraph on page 54, the last paragraph of his section, in his opinion, irrespective of all the savings or positive impact of any service provided or outcomes, it would be nullified and the expenditure would be deemed irregular. We move on, Madam Chair, to page 55. And this relates to Mr. Dave Gori. His name has been mentioned here several times. And we spoke to him about his interaction together with Mr. Kalima and other senior members of Eskom in relation to National Treasury approval. And I think it's important that we put this part to you. And you would have read this email before, the email that goes from him to Mr. Soli Chitanango of Treasury. And he says, thank you for your hospitality this morning. We look forward to further productive engagements in the future. As we discussed, please confirm for us that the practice note number SCM3 of 2003 entitled Appointments of Consultants is currently valid and effective for public entities, such as Eskom. We understand that this practice note and others will be incorporated into a new set of regulations once the review process has been completed. Mr. Chitanango responds on the 4th of February, later that afternoon, 2016, and he says practice note number 3, 2003 is still applicable until replaced by new instructions. After the promulgation of new Treasury regulations, the retainer contingency fee principles are not clearly outlined in the practice note. If you intend applying them, you need to do some further work to ensure that you do not compromise the principles of Section 217 of the Constitution and other legislation. Madam Chair, honorable members, I can confirm that almost every Eskom official at the most senior level that dealt with this project and put their signatures to these massive payments relied on this email suggesting that this was approval. We can confirm that this is not our position. It is not, Eskom never applied officially to Treasury. There was never an official communication to say that they go ahead. In any case, one can never rely on Mr. Chitanango's response and, to suggest that this is approval. It's clear they were being put on notice even by Treasury in that email, as far as we are concerned, that you need to do your own homework, you need to make sure that you don't offend any legislation. But they relied on this to continue with a contract that cost the Eskom and the country 1.4 billion rands. I'm going to skip 12.10 on page 56. I'm going to leave this section out totally because I believe that this person still needs to be scrutinized further in relation to her conduct. 12.11, page 58. This witness, and the witness is quite senior at Eskom, and I think she wouldn't have too much of problem with me mentioning her name, Ms. Ntombizotwa Mokwatle. Ms. Kwatle has provided evidence in this case. She has made available documents and several other audio recordings which are over 30 hours long, and these are yet to be transcribed or analyzed. She was one of the main negotiators on the MSA contract. But before the contract got off the ground, she was moved to another department. And what she says is in an interview that although she participated in the negotiations with McKinsey, she was not comfortable with some of the decisions taken on the issue of Treasury approval for deviation and respect of the remuneration model. She confirmed that it was not done and that she believed that this was a key and critical requirement. 59, page 59, 12.12. This is a witness who provided an affidavit that deals with the payments to Trillian. 12.13, this is a witness, and she's a business partner at Transmission and Sustainability. She's relatively senior, and her name is Ms. Ragini Ramkumar. She provided an affidavit which states that she came into the project to manage the sale of the EFC, Eskom Finance Company. She pointed out that Trillian was working on the research on the EFC from records and documentation. According to her, she had several meetings with 2 officials from Trillian. She informed us that it is likely that Trillian was providing a service to the EFC, on the EFC project for possibly a month before she entered the project. Ms. Ramkumar confirmed that she has consistently managed consultants and that by her calculation, Trillian could have invoiced in the region of about 3 million rands for those services. I can confirm that the evidence suggests that Trillian was paid 49 million rands for this piece of work, which would have lasted the best of 2 or 3 months. It is totally inconsistent with any product that Eskom received. I'm going to move on to page 62. 12.15, you would have already heard this witness, so we're not going to delve into it. We made attempts to interview her prior to having called to the committee, and her attorney gave her advice that you shouldn't make yourself available. On 12.16, I'm going to give you the version of Mr. Edwin Mabalane. We cautioned him in terms of his rights because we were under the opinion at the early stage that there could be findings that could be made or adverse findings made against him. He confirmed to us that at the time he was the Chief Procurement Officer acting. Mr. Mabalane provided us with a signed copy of the MSA Service Level Agreement. And this is the signed copy that except for the Secretariat of the Steer Court, no other official had seen or known of the signed SLA. When we spoke to him about the National Treasury approval, he was confident that the Eskom had received Treasury approval and that all the gatekeepers such as finance, legal, were agreeable to the project in the form that it was constituted and executed. Now you've heard enough about us saying that legal had not signed off on it. We did not mention that it is part of the body of our findings and report that finance, the internal consulting unit of finance, also rejected the model that was being applied for McKinsey. So you have your internal finance, you have your legal, you have many middle managers of staff, you have senior counsel legal opinion that are telling you not to proceed with this McKinsey contract, and they ignore all of that and they continue. On page 64, 12.17, we interviewed Mr. Prish Kavanda, also under caution. He confirmed that he was a project leader, contract manager after the project was agreed on. He was not there when the project was at the initiation or discussion phase. He stated that he became the lead negotiator, and together with Mr. Edwin Mabulana and himself, the project was brought to life. And of course, he then became the lead in terms of managing the contract. Mr. Governor is firmly of the view that all legal and policy requirements were adhered to by the project team. He stated that McKinsey brought Trillian in as an SDNL partner. He confirmed in his interview that Treasury approval for a deviation had been sought and received. However, in his last interview, he indicated that the approval was not required and that what he and his team wished to be confirmed was whether the practice note number 3 of 2003 was valid. Now we see this obfuscation and changing tack as interviews go along, and as evidence surfaces, the stories start changing as well. He confirmed that he had signed invoices in favor of Trillian and that he was acting on the letter provided to Eskom by McKinsey, which was signed by Mr. Vikash Segar in respect of the first corporate contract. Although he was not clear on this, it appears that he used the same letter or the fact that he knew Trillian were part of the project for it to be paid directly. We are clear on that today. It's our understanding from the letter that when McKinsey provided Mr. Prish Governor with a letter on the 9th of February 2016, and the letter you know about and you've seen, this letter was only for the corporate plan contract that Trillian were purported to be doing between October 2015 and early into 2016. But even in those, there were conditions precedent that any invoices provided to Trillian should have been subjected to McKinsey issuing a written confirmation of our satisfaction with the relevant services to be performed by Trillian to McKinsey, the correctness of the amount to be invoiced. We hereby agree for and authorize Trillian to invoice and to be paid directly by Eskom for services performed by it in pursuance of our obligations under the agreement. Now this letter, if you see the first paragraph, it refers to a contract dated the 29th of September 2015. So in our view, in our respectful submission, that permission is only for that contract and could never have been juxtaposed or pushed into the MSA contract. But having said that, honorable members, the evidence is quite clear that even on that corporate plan contract where Trillian got that 30.666 million, they worked totally independent of each other in Eskom. So there was no oversight by McKinsey over Trillian. Trillian worked directly under the office of the CFO, Mr. Anod Singh, and most of the work was managed by Mr. Prish Governor. And that payment as well for that portion of the work is irregular, the 107 million. Because what Eskom did was that they just jumped into boxes that were convenient for them. And when I say Eskom, I'm speaking specifically of these senior individuals in terms of when and how to pay. They always found some way to make these illegal payments. Now, in the MSA contract with McKinsey, we all know that it was a risk-based model and they would only have been paid out of their savings. But for this portion of the work under the office of the CFO, they did not use that remuneration model. They paid them directly out of the CFO budget, 107 million. And you'll see later in this report that the figures are shocking in terms of what they did. You know already that Trillian were only 2 or 3 people at most, or even if they brought in sub-consultants, that took them to 2025. We are consultants. These numbers are shocking. It can never be justified in anyone's lifetime in any country in this world. So I'll then take you to 65. Mr. Charles Karim, I think you've heard enough in terms of what he had to say. And this is a senior person in procurement telling us belatedly that I'm shocked at who we had here in Trillian, at Eskom. Shocked that they don't even fulfill the SDNL component of what we are trying to achieve as Eskom. Probably not shocked that they were paid 495 million rands irregularly and fraudulently. I take you to page 67, 12.19. You've heard this witness, Ms. Bianca Goodson-Smith. And I'd like to say to the committee that it should be clear that this report was written and compiled before all of the evidence that has since been surfacing to this committee and elsewhere. So we were also, in our respectful view, asking the right questions and getting the wrong answers. Madam Chair, I will move on because I think you'd be quite interested to listen to our factual findings and what we say should have happened in relation to some of the senior officials. But obviously, as you know, most of them have since decided to resign. On page 72, paragraph 13, we have spoke about the sole source justification of McKinsey. It is our argument in this report and our position and our professional opinion that in the first instance, there could not have been any justification for McKinsey to be used as a sole source, either on the corporate plan or the MSA contract. As big as they are, we know that they're a huge multinational company. We feel that they have been highly, if not criminal, and there's no information at this stage to suggest that they have acted criminally, but I think the Hawks investigation will bear that out. But if not criminally, in terms of being highly irresponsible, reckless in getting into Eskom, not applying their own due diligence properly, and foregoing their high ethical standards and values of any multinational. And I'm sure that they do have it, maybe not in South Africa just yet. Under the sole source justification, we say a lot of things, but on page 73, on the second paragraph, we say the overriding question is whether the incorporation of Trillian on the corporate plan contract was consistent with the sole source motivation. If McKinsey was the only company capable, capacitated, and experienced in this type of service, then how could Trillian's involvement be explained in being awarded or rewarded with a 30% value of that contract? This simply does not make sense. Now, when I say unethical, questionable conduct on the part of McKinsey, we say that because they know that they are not managing and controlling Trillian under their own contract. But they are satisfied, and I respectfully submit, out of greed, to be quite happy with their 70%, which is 70 million, and give away this 30%. It is, in some way, Trillian's commission for doing very little or nothing. It's their contribution to black economic transformation. Take this 30%, we're quite happy with our 70%. That type of attitude and approach can never be accepted. We move on to submissions to the Bartender Committee, page 75. Madam Chair, you have a culture at Eskom, or had a culture at Eskom. We honestly do believe that it's changing, and the change has come. That we just need to follow a tick box process. Do you need to do that? Yes. Do you need to do that? Yes. And you can get, or could have gotten anything through to that BTC and it would be approved. And this is where we say that the BTC, and by extension the board, are equally culpable. They cannot push that responsibility back to senior management. Neither can senior management push that to lower level members of staff. So they would get the submissions, they would probably read it, but they would, or not read it, but they would definitely approve it. Hundreds of millions of rands. So on page 76, Madam Chair, honorable members, 14.3, we talk about the wave tool of McKinsey. What we found disconcerting here is that Eskom were quite happy for the service provider, which was going to earn, 3 billion. Some say it would have been up to 10 billion in the next 3 years, to manage the entire process of monitoring what the savings were going to be. We were quite uncomfortable with that, because you're telling the service provider to tell you how much you would eventually owe them. Now, in a short 6 months, this very same wave tool, and we are not technical experts, so we're not saying that no savings were made. So, but we are just as cynical as yourselves and others when it comes to, or skeptical, wrong word, skeptical when it comes to how much savings could be achieved. In a short 6 months, they claim that they saved Eskom 27 billion rands. As a consequence, they should have been paid 2.7 billion. Eskom today, if reports are true, does not have money to pay its staff. Where is this 18 billion that you supposedly saved Eskom? And by Trillian's good fortune, they were going to get their 500 million and did in fact receive it. If this shenanigans was allowed to continue, Eskom would have been in a much deeper hole and crisis, because you would have found yourself 3 years down the line owing McKinsey 10 to 15 billion rands. And Trillian would have been much better off. Dubai would have received much more revenue and income, and there would have been much more apartments sold at the Burj Khalifa. Now, when we talk about conflicts of interest and fraud in our report, that includes, Madam Chair, senior officials, if it is proven, and I think the writing is on the wall, even if not in our report, but it will be on the wall once this Hawks investigation is thoroughly completed. Deep tissue massages in Dubai is a no-no. Having your families go to Dubai and spend Christmas, whether you're a cabinet minister or whether you are a Trillian employee or an Eskom employee, is a no-no. Page 77, Madam Chair, talks about the several work streams. That McKinsey and Trillian were involved in. And I'll read to you on 14.4, paragraph 2, 3, and 2, 3, 4, I'll read out. And we don't want to be naive. So we say in our report, while it would be extremely naive of us not to believe that value was achieved, serious questions remain about how the project was given life to, managed, monitored, and terminated within 6 months of it commencing. Our concerns stem from the evidence that the negotiations themselves took between 6 to 8 months. and we cannot understand that in signing the letter of acceptance, Eskom or McKinsey had not aligned themselves with the overall project. Its terms of reference, terms and condition, pay terms, and other legal and operational aspects. Although explanations by senior Eskom officials are muddled at best and conveniently changes as the conversation progresses, we believed that the early termination and significant costs of the termination suggest that these Eskom officials were possibly grossly negligent in the manner that they conducted themselves, failed to understand what they were plunging Eskom into, or intentions which can only be determined by a full criminal investigation into Trillian. On page 78, we'll move on. Sorry, to page 79. On number 15, we talk about the MSA contract with McKinsey. Now, admittedly, as we said earlier in our report, we don't wish to impugn McKinsey because we've never given them the right of reply, but we found that it would be fit and proper to make some comment on or give our views. The MSA contract with McKinsey is widely accepted or treated as an unsigned draft contract. Several documents, and this is important, several documents, minutes, and discussions at the steerco reveal that it was a fait accompli that the SLA was never signed. We listened to the steerco audio recordings. The discussions are patently clear. Mr. Mabalane speaks about the unsigned contract and says that although it was never signed, Eskom and McKinsey proceeded on the basis of mutual understanding and cooperation. Most officials confirmed to us that they had neither seen a signed contract nor knew that it had been signed. Mr. Governor himself was surprised in the first interview that the SLA was signed. He indicated that he never knew that it was concluded. He was aware of the letter of acceptance of December 2015. Given that this is the case with almost everyone interviewed, except for Mr. Mabelane, there's a distinct possibility that this was signed after the project was terminated. We'll skip the next paragraph. Taking note of what is elucidated above, the strongest conclusion which can be deduced from the set of facts is that there is significantly high probability that Mr. Mabelane and Dr. Weiss of McKinsey signed the contract after the 5th of July, when this contract was attracting media attention as pointed out above. In June or July 2016, in a recorded steerco meeting, both Dr. Weiss and Mabelane, and I think, and I stand to be corrected, Mr. Anod Singh, are clear in their discussions that we've come this far without a signed contract. We've done well. So obviously, I don't know why they signed it much later as we suspect. And we say in the last paragraph on page 80, this assertion is supported by several pieces of evidence, including a letter signed by Dr. Weiss himself, which was sent to Mr. Anod Singh on the 30th of March 2016. In the penultimate paragraph, it states, we acknowledge that the draft, and I've highlighted draft, of the service level agreement between Eskom and McKinsey entails that requirement of outsourcing a percentage of the total consulting fee to a supplier development partner. Why is Dr. Weiss talking about a draft when he knew that he had signed the SLA in January already? Madam Chair, honorable members, we'll move on. We're going to skip page 81, 82. On 82, we talk about negotiations, contracting, and termination. On page 83, we'd like to highlight on the top of page 83, it appears that a system of culture where the PFMA, Treasury, and other national legislation, and indeed Eskom's own policies may have become second fiddle to a poorly coordinated approach, and in certain cases self-serving and what now appears to be dubious manipulation, excesses or largesse, which had the exact opposite of the intended consequences of saving money and ensuring that the Eskom business became more robust and financially sound. To this end, McKinsey cannot but accept that it may have compromised its own business protocols, governance, and ethical principles by securing this business in a manner which demonstrates its acquiescing to a model which saw Trillian become a silent partner in its project. And Trillian, through its own seriously flawed ethical and business conduct, saw it effectively looting or being allowed to loot Eskom's finances by stealth. This, in all honesty, could not have occurred without the direct backing and or gross negligence of Mr. Anod Singh, Mr. Edwin Mabelane, and Mr. Prish Govender. G9 is neither qualified to, nor did it attempt to qualitatively and quantitatively assess the value of savings attained by both McKinsey and by extension Trillian in this MSA project. We say, if one discards the cynicism or skepticism that besieges this MSA project in the media and the eyes of the public, it is still, in our view, a tall order for one to readily assent to a proposition that in a mere 6 months, McKinsey saved Eskom the initially claimed 28 billion or the final agreed settlement figure of the 18.5 billion as real or actual savings. We move on to page 84. Madam Chair, how am I doing for time? I don't want to lose sight of that. Okay, thank you. I take you to page 88, which is still under the subheading 17, the negotiations, contracting, and termination. On the third paragraph, secondly, by February-March 2016, McKinsey were indicating to Mr. Singh that it had no contractual relationship with Trillian, and in fact had terminated the relationship, which at that stage could have only have been unofficial and or by mutual understanding or had been an intent. Now, the relevance of this, Madam Chair and honorable members, is that this is fact. McKinsey did, as you would know, inform Mr. Anod Singh and others that they had no relationship. They did so. They did so even in Steerco meetings. So Mr. Anod Singh and others cannot feign ignorance or, poor memory here. They chose to ignore that and still allow a company to illegally be on Eskom's premises and be paid for it. We say on the fourth paragraph, nevertheless, if by design or intention, McKinsey co-opted Trillian to the MSA, it could be seen acting in bad faith, irresponsibly, probably unethically or recklessly, if it brought on board Trillian, a relatively unknown company, into a major project. In our opinion, McKinsey appears to be content to accept Trillian around the table, more out of convenience and prevarication in that it was comfortable with its 70%, irrespective of where the remaining 30% STNL funds went to. We move on, Madam Chair. I know I've got limited time. Page 93, payments to Trillian. The first invoice paid to Trillian was in April 2016, soon after they were registered as a vendor on the system. The documents provided to Eskom show 0% black ownership. The payment is one of... Page 96. Let's move on. We'll go to page 97, Madam Chair. 20.1, very quickly, you know about this, you've asked about this, the 134 million in December. What's peculiar here and will be investigated and the evidence will be placed before the Hawks is the fact that when the contract stopped, very peculiarly, Trillian still got paid in December, 134 million. So Mr. Mabelana and his cohorts in Eskom at the senior level take a submission to the board and say they should be paid an upfront amount of 134 million. What's more peculiar is that Edwin Mabelane then writes to Trillian, Dr. Wood, and I remember Advocate Vanara asking somebody about that, writing to them to say, please invoice us 134 million. Now, you know, yeah, so we are owing you 134 million. Well, it's just about Christmas, you know. Flights are more expensive, so let's get 134 million for ourselves, our family and friends. Let me just move on to page 99. The graph talks about Trillian invoices, the pattern of invoicing, invoice 1 to invoice 5 in a short 6 months. First one, 26 million. Second, 107 million. Third, 99 million. Fourth, 134 million. And the final 154 million that we believe in our report and our findings. Trillian had no basis to benefit from gain share. They were not involved in, apart from not even being legally there, they were not involved assisting McKinsey in most of these work streams. So why should they then gain from that percentage that McKinsey was paid? Madam Chair, I am going to really move towards the end because I do not want to take up your time. 128, page 128. And our recommendations against Trillian. Further, specifically in respect of Trillian, the conduct and actions of one or more of the directors of Trillian, their conduct throughout the entire process, before, during, and after the engagement, presents prima facie evidence of possible criminal conduct, of fraud, and of money laundering. To this end, this investigation can never be seen complete until Eskom considers the following. And we said to them, this is already in August, September, the same report says to them, go and register a criminal case of fraud and money laundering against Trillian Management Consultants, its affiliated companies and directors who may have been involved in all of these things that we set out. It's there for you to read. On page 129, recommendations against Mr. Anoj Singh. In our opinion, it is our opinion that Mr. Anoj Singh should be interviewed by G9 in the case of Trillian. His evidence will place G9 in a better position to determine whether he has or has no case to answer to. We are convinced that as Trillian provided a significant portion of its services to this office, he is best placed to explain several of these transactions and payments. And I know that if the press call him, he's going to say, well, G9 said, we will still have to see if he has or does not have a case to answer to. I can tell you now that he has a case to answer to, both criminally and of course he's gone from Eskom, but still in terms of the PFMA. Should his versions be convincing in respect of his actions, he will be exonerated, obviously. However, as indicated above, there are serious questions about Mr. Singh. and he must provide answers there too. But in the wisdom of the previous board and Mr. Zetemba Koza, he didn't feel that forensic specialists should interview somebody that senior and who probably has most of the answers that all of us are seeking. We made recommendations against other staff members. I'm not going to go to that. On page 131, consolidated contraventions, we tell you what we believe were contraventions by, or told Eskom rather, let me correct that, in September, what the charges and contraventions were of Mr. Edwin Mabalane, Mr. Prish Kavanda, Mr. Charles Kalima. And we know what happened. There's suspension, unsuspensioning, there's review of forensic reports that need to take place. Board tender committee, we feel that they should be investigated for their culpability. We don't suggest that it's criminal at this stage. That will be born out of the criminal investigation. But it's clear that there are PFMA transgressions, and according to the law, that's criminal in itself. I'm going to close, Madam Chair, and thank this honorable committee and members for the opportunity for us to present our report. We tried our best, and I'm sure that this will yield results, and we thank you for the opportunity.
Thank you very much, Mr. Morgan. I think, members, the document that is in front of us, as have been said already, it's readable. It's readable. I think we will be able to read it as members and get the exact detailed report from it. Let me thank you for coming and giving us this report, but I will now give over first to Advocate Vanara if there is anything that you think you should interact with the G9 group. But the unfortunate part of it, Advocate Ntsabeza, you would not be able to respond to any questions because you are not under oath, and the other members will also not be able, but you are given an opportunity to write notes to him, to Mr. Morgan, so that he responds the way you would wish him to respond to questions that are put to him. But he will be the only person that will respond to questions. That's
I appreciate that, Ms. Chair.
Thank you. Advocate Vanara. Oh, before you, Advocate Vanara, you know, before I forget, there's something very much interesting that I would wish everybody, every South African to know who is Trillian. Because to me, I am becoming so suspicious in hearing, when every time I hear this Trillian name, I ask myself, who are these people? Are they a black-owned company, a company that has really BEE status? Is this Trillian company a company that does exist, or it's just a name that came up for people to use so that they can solicit money from Eskom or from anywhere in South Africa? So it's just something that came into my mind, that this Trillian, is it an existing company? Is there something called Trillian that you can point out and say, this is Trillian? I'm just asking those questions in my mind. Advocate Vanara.
No, thanks, Chair. I don't have any questions.
Thank you very much, Advocate Vanara. I will now give over to the members. Member Mazon. Member Swart. Tsedi. Dlamini, Singh, Luyenge, and Mganga Cabashe. Oh, Mganga Cabashe, Mr. Swart, you, Mr. Mare. My apologies, Mr. Mare, and Miss Rando. In that order.
Thanks, Chair. Chair, as you said, this document is self-explanatory, and we are going to read it in depth, but obviously certain things have to be put on public record, and that's what the purpose of this inquiry is about, is so that the public knows what we know too. We've heard a lot from people that have testified here as to the squashing of reports by the boards. We know for a fact that PwC wrote a report, Denton's wrote a report, there's the PwC report. I mean, there are a lot of reports that have been squashed by the Eskom board. Now, in the attempt of squashing these reports, Eskom in what I consider to be probably one of the greatest heists that was ever almost pulled off. They tried to say that these reports contradicted each other and that reviews had to be done and further opinion had to be taken. Can you tell me, this G9 report, who specifically requested the quashing of this report? Just so that we have it very clearly on record, who instructed this investigation to be stopped? And was this report taken on review?
Honourable Member, Ms. Mazzoni, from what we know, very reliable information as well, because many very senior people in Eskom place their trust in us. If we're to leave it at the feet of one person, and we don't want to be reckless here, that one person is Mr. Zetemba Khoza. I can say, hand on heart in terms of what I know, is he spoke to many people in his deliberations and discussions about this report. And some of the things that he said was, this report is not worth the paper it's written on. It is not substantiated. And I can go as far as saying that he ventured into two territories which are found disgusting. One, he would make statements like, do you know that people get killed for doing these types of investigations? And who is this G9? I mean, it's going as far as suggesting that we are agents that have been planted at Eskom. One day, those pieces of, I hope he does not go and deny it, because he'll be shocked in terms of what would be then put on the table. So he must, at an individual level, take full responsibility for stopping this investigation, squashing it, and deeming it a piece of junk. We take umbrage to that. We are offended and insulted. But having said that, when you work with people that are, and I say this with respect, that want to be politicians in a business like they want to be, this is what happens.
I completely, I mean, this committee understands that, that kind of threat that was made to you was commonplace. It happened to members of this committee. So, all I can say is I personally know exactly how that feels. Sean Maritz, I am reliably told, wrote to you and requested you to withdraw recommendations. Did you ever receive a letter from Sean Moritz?
Madam Chair, no, there was no such communication from Sean Moritz to ourselves that said we need to withdraw our report. But what I can say is that when he became the acting group executive, we requested to meet with him to present the very report that we presented to the board before him. And we had a meeting with him, and what was startling in that meeting, and I say this with the greatest respect to Mr. Moritz, you could see a stooge sitting in front of you. When we put the report on the table, he almost pushed it away. And he said to us, before I even entertain you, can you confirm to me that you didn't go against Eskom's instruction and continue the investigation when you were instructed to terminate? That took me by surprise. And then between himself, the head of forensic and the head of internal audit, we were asked to leave the room. And there was a 10-minute deliberation between themselves. We were called back because I think he was convinced that we did not continue the investigation after termination. It was just providing him with a report that we'd already provided. I think it was either too much of a hot potato for him, but I would suspect, and what I wondered about is how would he have known that the report was terminated? Because it was the board that had terminated it. I don't even think Johnny Tlatla and others would have known. So the deduction that we made is that he was explicitly told by Zetemba Khoza that if they come to you, make sure that they didn't go past where we told them to stop. So that's my position on that.
Okay. Now, one of the reviews that happened that was kept completely confidential and certainly not ever brought into the public domain was a review done by Advocate Motimele, and it was an opinion piece that was done. Were you informed that this opinion was being sought by the advocate?
Madam Chair, I heard that, we heard that through the grapevine, that it was being taken. We were surprised because it's quite unusual to take a forensic report to review. These are not court decisions and findings, but be that as it may, we thought it's within the right to do. We were not fazed by it because we know that it'll stand scrutiny. We were surprised in terms of what came back from the senior counsel. We respect that he's giving a legal opinion, but what we can confirm that he never called us to interview us to explain some of our findings. He never had any of the annexures or affidavits or documents, but we are given to understand that the opinion suited Eskom in that he was saying that you don't really have to act on the report. You have some legal basis to pay Trillian and McKinsey. There can never be. I mean, in my limited opinion, and we have senior counsel on our side as well, and he's not going to put his neck on the block on some flimsy, unsubstantiated report.
You see, Chair, the reason I ask this question is because I think we all know the best way to get two opinions is to get two advocates to read the same document. And depending on whose side they're on, they give you the opinion that you want to hear. And that's just life, and that's why we all have our own advocates. So, Chair, I just wanted to know, because this Motimele opinion, I do find it highly disturbing that we as the public, and certainly we as the Public Enterprises Committee, were never made aware that this opinion had been sought. And I've read this opinion, and I can corroborate that certainly it shows that no request for interviews was made with G9, no request for interviews with anyone was made. And that disturbs me greatly. Chair, I think, all the information that we have is here, and we know exactly where we stand with this. But I would like just one last piece of information from G9. People have to face criminal charges and have to be held criminally responsible for what's happened at Eskom. This committee will make its own recommendations, and obviously the very reason people like yourselves are called in to give evidence is to assist us in formulating our recommendations. And it's not to say that we'll take what you say as the alpha and omega of how we create our decisions, but you are experts in your field and we look to you for expert opinion. In terms of people that should be held criminally liable for the fruitless, wasteful and illegal expenditure at Eskom, and bearing in mind that you are underprivileged and cannot be sued in your personal capacity for making your opinion known. And I say that because it's important that you know you can speak freely here. That's why we swear you in under oath. In your personal and expert opinion, who would be held criminally liable for actions at Eskom?
Madam Chair, in terms of the PFMA, at least at this stage, I think all individual members of the Bartender committee. In terms of the PFMA and criminal suspicion and the evidence that we have and we've seen and we know that we would get by assisting the Hawks, Mr. Anuj Singh should start packing his bags to go to Sun City, not the one in Rustenburg, but the Sun City in Johannesburg.
Thank you, Chairperson.
Thank you, Honorable Mazone. Honorable Swart.
Chair, I am just very grateful to G9 for coming today to set the record straight. And I was indeed shocked when Mr. Anuj Singh said that you had withdrawn your report during that cross-examination. So I'm very grateful that you've come to set the record straight. And you've made it very clear. In words, you've said, Mr. Anuj Singh, what he said is not true, is inaccurate, misleading, and a fabrication. So you have said Mr. Anuj Singh lied to this committee under oath, and that is very, very important. And we accept what you've said here because there's no reason why you would come and fabricate what was said. We're also grateful for what you've shared on the whole Trillian detail and the procurement process and the lapses that took place, notwithstanding the internal legal, internal financial, middle management, that there seemed to just be a total disregard for internal processes and a continuation with this contract. And I want to share Advocate Ntsibeza's view that one shudders with disbelief that such widespread theft and criminality has taken place. And I'm sure as you've been following this inquiry, you've seen the broader capture of Eskom with the coal contracts, everything. And we see today the challenges with the Optimum mines, all being placed under business rescue, the shocking state, on-it contracts, mines closing down, loss of jobs. But this particularly, that your report is very, very helpful. And again, it follows a pattern of reports like the Denton's report, other reports. As soon as they reached a certain stage, they were curtailed. And I appreciate that you indicated your shock that when you presented your report, your interim findings to the board, within 2 hours, your contract was terminated. But I would suggest that there might have been other reasons besides the important aspect of you indicating, as you should have. I don't think you need to have any regret that you indicated that you're pursuing breaches of fiduciary duty by the board. But I think phone calls were made. I think instructions were obtained from Guptas and Gupta-related people because you suddenly had very serious information about Trillian, and we know the links with Dr. Eric Woods and the Guptas and their associates. And I think that is actually what took place that caused the termination of your contract. What I would like to just ask you, and what we've seen here, and you capture it on page 83, where you say McKinsey cannot but accept they may have compromised its own business protocols in a manner acquiescing to a model which saw Trillian become a silent partner in its project. And Trillian, through its own seriously flawed ethical or business conduct, saw it, that's Trillian, looting or being allowed to loot Eskom's finances by stealth. And so I share your almost sense of outrage of those invoices being paid, and the last one, 154 million, without any work being done. And we've got the evidence from Bianca Goodson, Ms. Masila Matupo, that said that money should never have been paid. That's from Trillian people themselves. That information is from them themselves. And so this is a very helpful document, the insight, the evidence, and obviously, as our chairperson indicated at the outset, we are continuing our work, notwithstanding that there is a commission of inquiry, and I'm sure you might be called or offer your evidence at a commission of inquiry. My concern now, and I'm glad you've emphasized that you are working with the Hawks and law enforcement agents, but what I found outrageous, and I'm sure you'd like to comment on this, is that you presented your report in August. The board knew what you had said, and they came to this committee and stood a totally different spin on the whole Trillian matter, whilst they knew what you had already been, your findings were here. And I find that totally outrageous, Chair, again. And I would tend to agree with your assertions against Mr. Khoza, who had your interim report and then came to this committee. But what I'd like to ask you, what we found at one stage during our investigations, the Eskom board came and was very keen to recover the funds from McKinsey and Trillian. Then we saw in January, suddenly there was an about turn where Mr. Sean Maritz suddenly said, no, there's nothing wrong with the contract with McKinsey, and if I tend to understand correctly, with Trillian. Would you agree with that? Obviously, on your document here, there was significant problems with that contract. Would you comment on that, please?
Honorable Swart, in terms of the recovery of the funds from McKinsey, who generously offered to take it back, just as you, we were quite surprised that Eskom had not even gone for that money within a week. They're still trying to legitimize those payments. So, you know, to McKinsey's credit, as you've said before, and I think Honorable Mazzoni said that they at least want to give back the dirty money, because it is dirty money. And the reason that I think, and it's only a personal opinion, and you know, so it's not an expert opinion, is that these crooks that we have out there know that if McKinsey's money is returned, then that 495 million must come back as well. And they know that, you know, most of it is gone. So legally there'll be some pressure for Trillian to pay back. So the fact of the matter is, out of the when McKinsey returns that money, thankfully, the rest of the money with Trillian, I'll be very surprised if you're going to get much of it back.
You indicate on page 129 that one of your recommendations is that G9, and can I just, the gist of this report was given to Eskom in August, I presume. You've added a little bit here and there, but the main, I would assume that what you've said here on page 129, can you just confirm whether that was given to Eskom as part of your contract? Because it's very important to have an understanding of what was before Eskom when they came to Parliament. The board I'm talking about, the board then. Would that be on page 129? Would that have been before them? The top paragraph, the top section, bullets, all those bullets. Because I'd like to just repeat those bullets.
You want me to repeat the bullets?
No, I'm just asking you, was that was that part of your report that you gave?
No,
me?
absolutely. I mean,
I assume that.
the 90%, if not 95% of this report, as it stands, was in the hands of the Eskom board at that stage. We made 9 copies and delivered it to them the second time when they were having a board meeting. So they would have seen it, and we know that they've deliberated on it internally. But obviously not for the good of the country and Eskom, but what's the best way to cover this up and close it down?
You see, here you say on bullet 1, there was no contract between Eskom and Trillian. There was no contract between McKinsey and Trillian. Suspicion that monies paid to Trillian may have left the country. You already are indicating then that monies may have left the country. The subcontracting of 77% of its invoices without official in Eskom contravenes the prescripts of BBBEE legislation. Trillian may have misrepresented their intentions. That's fraud. And such manipulation and misrepresentation called Eskom actions to pay monies which Eskom had no legal basis to pay. That's in August already. And we have the board come in here and put in a spin on this, but no action is taken. In fact, your services are then terminated. Is that correct? After that?
That's correct, and I fully confirm that this piece of the report was in their possession. So here again, if they came and put a different spin or said something else, they were lying to you.
And no action. This is something you might have followed in my involvement in this committee, as well as my questions in Parliament from the Justice Committee perspective. I've said from the word go, from the Public Protector's report, which was referred to the Hawks and the NPA in terms of the Public Protectors Act, there was nothing to prevent both the Hawks and the NPA investigating. Some of these allegations were in the Public Protector's report as well. But we saw no action, notwithstanding your recommendations to institute criminal action then already, no action. The only action we now see is in January that you refer to on that page as well. Is that not also a matter of great concern to you, not only as having done this with your extensive background as an investigator, but as a citizen of South Africa? I'm sure you are outraged by this.
You know, of course we are, but because we are professional forensic investigators, we try to keep the emotion a little out of it. And yes, they had a fiduciary duty to go and register that case in August, September already, and they chose not to. So, you know, it's criminal. I mean, there's nothing else one could say about this entire thing between McKinsey and Trillian.
And I'm sure Advocate Nsebezi would also advise you that once you bring a report like this to directors, they are under an obligation in terms of the Prevention and Combating of Corrupt Activities Act to act on that investigation and to report it. So by not reporting it and by not taking action, they are, in addition to breaches of the Companies Act for fiduciary duty, the PFMA Act, they're in breach of the Corruption Act for not taking action on your recommendations. Would you be in agreement with that?
Yes, we are.
So it's quite sad that so much information was at the disposal of Eskom, where they could have taken steps to recover and to stop the illegal payments of Trillian. But when you see the bigger picture, those Trillian payments had to be made to benefit certain connected people. And you've exposed it here very well. But the sad part is no action was taken following this excellent recommendation. And I would agree with you. And yes, there has to be a right of reply. And of course, preliminary reports that would come out from our side. But there has been very serious breaches of fiduciary duties here. And I think it's absolutely disgraceful. But I want to just, one aspect here on page 129, where you indicate Eskom may be able to institute civil action. Can I just contextualize that sentence? Was that something you said then, or is that more updated? Eskom may be able to institute civil action against Trillian directors and recover through the asset and forfeiture unit of the Hawks or police. should criminality be suspected and or proven. Was that, would you, it might be an unfair question. I'm just trying to ascertain whether it was in the report then or is it more recent?
No, Honorable Swart, all of this would have been in the reports that we were providing to them at that stage. It was an almost complete report. If there were any changes since then, it would have been minuscule in terms of adding affidavits of witnesses and things. But the findings would have already stood at that point in time. We said to the Audit and Risk Committee at that stage, verbally interacting with them, that they had to go after the money. And we said to them, this case is all about chasing the money. And you know, anybody could tell you that. But they just simply, obviously didn't care.
You see, the issue that I raised when we met with the board earlier, and this is the new board, is once the asset forfeit unit, which is under the NPA, gets involved, and they've now got a preservation order against McKinsey and Trillian, what is left of Trillian. But once that money is recovered, it doesn't go to Eskom, sadly. It goes to the Criminal Asset Recovery Account, CARA. And I said, because Eskom did not respond to claim that money from McKinsey, 1 billion rand, that they came here and offered us, that money now is going to go to the Criminal Asset Recovery Account, should they recover it. And that's the sad part of this whole debacle, is that you came with excellent investigation, with evidence. It was not acted on at that time. And indirectly, Eskom is losing further billions and billions of rands. So I just want to thank you from my side for taking the trouble at cost to come and clarify what I had raised with Mr. Anod Singh. I'll be studying your document very closely, but I just want to acknowledge the incredible work that you have done. And we are very mindful of how reports and investigations were curtailed. But it's a new day, and we hopefully, what you've done here, one will be able to continue with that investigation, and that we will see justice, and that we will see those that are criminally and civilly responsible for the debacle at Eskom be brought to justice. Thank you very much, Chairperson.
Thank you very much, Mr. Swart. Oh, Mr. Tsedi.
Thanks, Chairperson. Let me thank Mr. Murugan for a very comprehensive report as presented. About Arnold C. You raised quite a number of issues which confirms what other witnesses who came before here presented. The issue of him allowing Trillian to provide services without a valid contract. The issue of you not being able to find any formal application from Treasury for deviation. The controversial trips to Dubai. These are some of the issues that have been raised earlier. But I understand you to be saying you still want to pursue another interview with with Arnold Singh. Why would you want to still proceed to engage with Mr. Singh over and above your findings?
Honorable Sedi, one should recognize that the report almost in its entirety was last year. So much has happened since that has changed the ball game. We wanted to see him at a time that he was still an employee of Eskom, to give him a right of reply in terms of what we were finding and to get his views and his opinions. Since then, I think we've crossed that bridge a long time ago. So we don't need to see him now. I think he needs to see the Hawks.
Mr. Mabelan, what was this explanation about the 134 million that was paid, the invoice that was paid in one day? What was this explanation about this 134 million? Because the report says you managed to interview him as well in the course of you investigating these issues.
Honorable Sedi, the Mabalani interview was very difficult. You know, I can't tell you what he told us, to be honest. You get some people that are quite efficient in spinning stories, so I can't say that we came away having any understanding in terms of what he told us. But he did acknowledge that he'd written that letter to Trillian about reminding them to claim 134 million. And I don't think he saw that as being unusual. We do see it as being highly unusual. But so, he never really gave us decent responses.
The round robin approvals of contracts in Eskom, in the course of you doing your work, was it the first time that you come across this kind of an approval of contracts in Eskom?
Honorable Sedi, no, it's not the first time. In fact, it's not unusual. It is in the procurement policy. Round robin approvals can take place. So it's not illegal as such. And in this case, the approval round robin issue was not at the approval of the contract per se. I think it was very early on giving the executive a mandate through round robin approval to go and talk to McKinsey. But having said that, from our experience, not only at Eskom and a lot of these state-owned enterprises and government departments, when you want to push something illegally through, you'll rather do it from the back of an email or sitting in your home. So you approve from wherever you are. So there's no real discussion, engagement, and questions and risk identification. So the board member will get a few documents to say we want to do something, and if they're quite happy with it, they approve on an email. And of course, that opens risk and corruption and all of that to come into play.
It's fine, understand. You are saying it's unusual. It's not unusual, but my interest is what was irregular about this kind of round robin exercise. This specific one that we're talking about.
What raised our concern here is that you have a situation where you are going to enter into a contract with a company that's going to run into the billions. So in our view, at the very best, you should be thrashing this out in a meeting, a physical meeting, not through the internet. So that's where we had some discomfort about that, and we felt that, it was more to show that, the attitude and approach of some of these board members or board members.
You say as in April 2016, Trillian company was not a BBB EE company from the report. Do you want to tell us now they have a certificate to be a triple BEE company? Because the report says then it was not, you could not find anything that confirms that it was a triple BEE company.
Honorable Sedi, I don't think we've looked after that in terms of whether their structure had changed. But what we can confirm is, from what we know, is that most of those that were supposedly directors, like the Goodsons and others, Mosila Motebo, they have since left. So from what the current situation is that we only see, if I remember correctly, Dr. Wood as being the only director on Trillian.
No, I'm saying, how do you arrive at a conclusion that they are not a triple B EE company without any document to confirm that? Because my take is that, because the report says they are not, and my assumption is that is because you could not find any certificate to confirm that.
Well, we have the document in our possession that Trillian provided to Eskom, showing that they've got 0% black shareholding. So the document and the evidence is there.
The report talks about the visit to Telkom by 3 foreign consultants. You remember? I don't remember the page. 3 foreign consultants from Dubai. I need to clarify it on that one. What were they coming to do? From the explanation, obviously, I suspect Mr. Mabelani could have clarified that particular aspect.
Those 3 foreign Dubai visitors, from what we understand from Mr. Mabelani, and he gave us this information off the cuff quite late in the investigation, was that they were brought to his office by Bianca, and the possibilities that they were some of the consultants that were brought in to assist Trillian in whatever they were doing at Eskom. So we don't know who they are, but I think what we do know, as far as some of the things that Trillian were doing, is they were bringing in a lot of consultants. McKinsey did that as well, and they came from India, they came from Dubai, and they were taken to our power stations for 1 or 2 days, and then there's a 60 million rand invoice that follows.
Some of the people that you interviewed says that Eskom was advised that the agreement by Eskom, between Eskom and McKinsey, could be illegal before it was even entered into. In the course of you doing this, conducting this investigation, were you able to find anything to confirm that advice from the legal advisors?
Honorable Seti, I think what the little that I can say, obviously it's the lawyers that must pronounce on this from a legal point of view. But from our view, in terms of the documents and what we see, and in terms of what the legislation of this country provides, it cannot be seen to be legal if no treasury approval was received, and the methodology used was wrong in terms of legislation and policy. Now, McKinsey may argue that this is Eskom's problem. If you don't do your job properly and you sign on the dotted line, it still remains a valid and legal contract.
No, I agree. But my question is, if there is no way a legal person can provide a legal advice without any document to confirm that this particular contract is illegal, and we therefore advise you not to proceed with it. In the course of you conducting this investigation, were you able to find a document from the legal advisors with respect to this particular contract?
Which said you should proceed or you can proceed? No, is that the question? Whether there was a document from legal that said you can continue? No, there absolutely was not.
The reasons to terminate your investigation, because my take is that when you were appointed to investigate this contract, surely there were terms and conditions. When the contract was, when your investigation was stopped or was terminated, what was the explanation that was given? Did you at some stage even try to challenge it? Because surely the contract stated by when are you supposed to complete, and obviously there are some terms and conditions. Are you able to talk to that particular aspect?
Mr. Honorable Seti, we are obviously on a panel of experts. One could potentially challenge things like this, but because of who we are as a company, sometimes you need to follow what the client tells you. Not illegally, and I don't mean, telling you, asking us to do anything illegal. I mean in terms of whether they still want you to work or to extend your mandate or your scope. So we have a good relationship with Eskom. The instruction to terminate and stop came from the highest accounting authority in Eskom. So we were waiting very patiently for this day, and thankfully it has come.
So I want to go back to the issue of C. You wanting to pursue a follow-up interview with Mr. C. And I want to check if you want to interview him as part of the contract, or you want the committee to assist you to arrange a particular interview to deal with these particular issues that we're talking about.
Honorable Sadi, I don't think we'd have any legal basis to ask him to come
And
to
I'm sorry, and I'm raising this thing because you indicated earlier that the contract, the investigation has been stopped as of now. So I want to check if you want the committee to assist you to arrange for another interview with Mr. C to check if there has a case to answer or not.
What we'd like the committee to assist us with, and I don't think, I'm sure that Eskom would now stand on its own, is to ensure or to request that we be allowed to continue with this investigation to take out further rotten apples if they exist, and if the evidence exists in Eskom. In relation to Mr. Anuj Singh, of course we'd love to talk to him. But I think we will be offered that opportunity if Eskom allows and pays for us as a consultancy company to be attached to the Hawks investigation. And then that would happen naturally.
Thanks, Chairperson. No further questions.
Thanks, Honorable Tsedi. Honorable Dlamini.
Thank you, Chairperson. The cause of the investigation, according to your report, it was from an anonymous letter. It talks to the issues of a supplier that is paid within a day. When you started with your investigation, did you check if was that the norm within Eskom? Was it the only company that was paid within a day? And also, it says here, within a day instead of 30 days. What informs the 30 days? Is it within the Eskom systems, or how did you work around that?
Honorable Member, in terms of the accounts payable policy at Eskom, as far as we know, the payment turnaround, and this is probably more from an administrative posture, is that black-owned companies should be paid within 14 days at Eskom, and all other companies within 30 days. Now, when we spoke to the most senior people, like Kalima and Mabelane, they say, well, we can do it. It's not out of the ordinary, and we have done it before. It's a small black company that we had to pay this to, so we pay them in 2 or 3 days. So nothing wrong there. as far as they are concerned. If you talk to most of the staff that work in finance and procurement, they will say, no, it shouldn't be done and it's not the norm. And if you ask us, we say it's highly questionable that you could pay so much of money in a day or two without even doing your proper due diligence in terms of, what are we paying for? Do we have the product? Have the services been rendered? And in all of the invoices, I'm not sure if you've seen it, but we have them. It's just Mr. Govender and Mr. Mabalana appending their signatures on invoices. And it could go through the entire system and get paid with flimsy documentation. That is abuse that exists there.
On your investigation, page 28, you are saying there were several key individuals that were not interviewed due to the time constraint and limited mandate. Do you have the names of those key individuals that you couldn't interview, that you wanted to interview according to your investigation?
Honorable Member, yes, we do have a list of names of people that we wanted to and still wish to speak to if we are allowed to.
And who are those people?
Well, some of them would be former members of staff. Must I mention names or?
Yes, names, please.
One of them would be Mrs. Maya Naidu, who is quite senior in finance. She was one of the most senior persons under Anod Singh. We have spoken to her to some extent. We didn't find what she was saying to be quite compelling or acceptable. But at some point, the relationship between herself and ourselves went sour. And she obviously then used her position and links to people more senior to make sure that, we kind of back off. But I'm sure we'll be having pleasantries soon, and if allowed to do so.
Is that the only key individual? I'm just talking key individuals. That could
No, it's just that they don't come to mind now. There are many at various senior positions in procurement and finance. But also, Honorable Member, one needs to understand is that there's various lines of inquiry that we've identified that we still need to pursue in relation to this. And it's only at that stage that, those people, could or should be seen.
Did you interview Marcella Koko?
No, he's got nothing to do with our lines of inquiry, so we've not had the pleasure of meeting him or speaking to him.
I would doubt that, because he came here and one of the questions when we asked him, what were you doing in Melrose Ark, in the offices of Salim Issa? He said he was going there to discuss payments and the workshop that was conducted by Trillian and McKinsey. So if you're saying it's got nothing to do with this one, I would doubt that. It's just that your interview has come to an end, so or your investigation. But that was his own submission here to say he had a private meeting with Salim Issa in Melrose Ark to discuss these issues relating to the same payment. So I think somewhere is involved, but let's leave that. The same on page 28, you are saying I'll just read the allegations and widespread reporting, which points to possible criminal conduct by individuals or companies, was not fully or satisfactorily investigated by G9 through no clear mandate and support of the interim board. What are you trying to say to us is that your investigation, it did not lead you to where you can say there's criminal conduct. What is the essence of your full investigation?
Honorable Member, what we are trying to say there is, no, there is criminal conduct and there is excesses and contraventions of policies. What we are saying here is there's more rooms to go into and you're not allowing us to go there. So this investigation would have morphed into getting more evidence against more officials who've contravened policies, either linked to Trillian or McKinsey, that need to be held accountable.
There's mention on the report of Trillian associates who contributed to the purchase of Optimum. And then there is Trillian Regiments and Albertine. Is that correct?
That's correct, Honorable Member. But remember, we were reflecting on the state of capture findings. And by mentioning it, we were looking at whether there was any conflict of interest that we could pursue in terms of the conduct of Ms. Firoshni Naidu, who was one of those people on the BTC at the time.
So did you speak to the, or consult the public protector's office just to get the evidence in terms of their own contribution to the purchase? Because part of the report or the investigation, and what we, I think going back to what the chairperson was asking, that who is this Trillian, is that we want to understand where is this money going. It must not just end at Trillian. If we can be able to trace it, now that there is a link of Trillian paying for the same coal that is already under investigation and under questioning, it's something that could help this committee, because eventually the intention is not just the evidence is coming out in terms of wrong contracts and everything, but we want to see where was the last rand it ended up to, on whose pocket. So did you consult the public protector just to check the evidence in terms of them paying and the amounts that they paid for towards the Optimum coal mine?
Honorable Chair, Honorable Member, what I can say as far as that is concerned is, with the limited time that we were afforded and the termination coming, there are many avenues that we simply just could not pursue. But I agree with you, these are very important questions that need to be either investigated by ourselves internally or investigated by the Hawks. And it's all about where has our monies gone to. And I have very little doubt, and having spoken to the investigating officers in the Hawks and dealing with them, that they are committed to ensure that they go and find that money, if it exists anymore and where it is. So,
Can you just repeat that last line? You're saying what doubts that the Hawks are committed?
No, I don't have doubts. I'm sorry if I didn't. No, I don't have any doubts. I'm quite satisfied that in our discussions, and including discussions inside of Eskom, that we are now traversing a different pathway to get Eskom and the country back to where it should be. So in a short 12 months, I think much more is going to come out into the public domain, and for the benefit of Parliament as well, in terms of what has happened here.
There's Mr. Mutli here, whose wife is working at Eskom, but who's also a special advisor to the Minister of Minerals. And the same Minister of Minerals, that's when the whole procurement of Optimum, it happened under his leadership. Did you, by any chance, get to access that special advisory agreement or arrangement between this Mr. Mutli and the Minerals Minister? Just to try to link back, because what we're trying to see now is to say if we can get links, because it's under this ministry or the minister that the whole procurement of this mine or purchase of the mine, it happened where they were given prepayments and everything. And now that the wife is working on the other side and the husband is advising the minister, did you get more information around the advisory agreement or, between Mr. Moodley and the minister?
No, Honourable Member, we didn't really investigate that aspect, but I believe that Bowmans and Gilfillan are looking at some of these aspects, and if and when the Hawks really get their teeth into this investigation, those types of things would be pursued.
Okay, finally, you're saying according to your mandate, your reporting, your mandate and the lines of reporting on your investigation are with the executive, even though you are saying that you observed that the interim board was becoming too involved. On the executives, who were the people that were supposed to report to after you concluded your investigation? Were they from the CEO? Who was there? Just the CEO, COO, who was there at the time?
Well, Mr. Honorable Member, we report to the head of forensic, and it's the head of forensic that would then take our reports to more senior executives. But when you have an investigation like this, quite routinely the CE calls us in, or we ask to see them to explain. So we've met Mr. Johnny Ladler, we've met Sean Moritz, we've met obviously Mr. Koza once and some of his board members. So that's the general reporting line that we followed in the Trillian investigation.
Did they give you a contract and did they pay you?
The payment, firstly, yeah, well, you know, this is how some of these things, we worked on this on a real shoestring budget. And that's probably another thing that some of these people that do not want investigations to continue at the highest level, make sure they give them as less money as possible. But we're not here to cry about money. But having said that, we invoiced in September. We only paid 2 weeks ago after several letters to the more senior people in Eskom to say, what happened about the 14 days, friends, for us? So if you're not a friend of Eskom, you wait 6 months, and if you are, you just need to wait 1 day.
Thank you very much, Honorable Dlamini. Honorable Singh.
Thank you very much, Chairperson, and good afternoon. Chair, I don't want to belabor the issues that have been raised. And I think Honorable Sedi partly covered me and Honorable Dlamini. Firstly, I must say I'm very impressed with this report, albeit the fact that it was done in 6 weeks. And I'd like to know, if you had more time, how much time would you have needed, and what else do you think you would have uncovered? And whether or not you think, Mr. Morgan, that there isn't prima facie evidence here for people to be prosecuted in this report as it stands, incomplete as it is. My second question would relate to, have you done any other work for Eskom or for this anti-corruption and forensic department, and when did you do the work, and what was the nature of the work, if you did any work for them in the past? And you mentioned some names of people, well actually just one name in response to Honorable Dlamini. But are there other people, do you think, that would have been seriously implicated in fraud and corruption had you continued your investigation? You seem to have had carte blanche access to documents and individuals within the institution. So if you can just respond to that. Just want to be brief. Thank you, Chair.
Honorable Singh, thank you for that question, and we appreciate your comments as well. In relation to doing other work at Eskom, from a forensic point of view, the answer is yes. There's been several, I wouldn't say similar size cases, but several cases that we've done. One case is related to an American company called Converge. There too, we were shown the door. We found that Eskom entered into a contract with this company. I think it was for about 225 million. They were paid a 50 million rand upfront fee. And when we started our investigation, we found that that company was almost bankrupt at that stage. it was under hostile takeover in the States. Bottom line is, after back and forth, we've even met Brian Molefe about that one. And, you put on ice. And I think it took us a year trying to get meetings with him and others, and another year to be told, no, thank you, it's time that you go away. So so that's one investigation that we were doing. We also assisted, and the senior counsel was quite involved in the Denton's investigation, senior counsel in SABC, and he knows what happened then. I think you know what happened there as well. So the culture is like this as far as we are concerned. If you are investigating middle management and junior employees, it's fine. Go ahead, they'll pay you, and they take them to disciplinary, and they get punished for it. But if you ever dare trying to touch the executives or the board, then you are an enemy of the state. And that's where this commission, the state of capture inquiry, and yourselves and the Hawks should be dealing with. You need to clean up from the top. And I think you've said it. I must say, I haven't met this new board, but we are a new IGCE. But I must say that what we see now in the last few weeks, there's a definite turnaround in terms of dealing with these governance issues. They are serious. Forensic is serious. I can tell you that they are being inundated with tip-offs. Forensic companies are being called in to deal with it. And, so that's a positive for the country and for Eskom. In terms of others related to fraud, in terms of what we had uncovered in 6 weeks and the lines of inquiry and where the investigation was taking us, it was clear that we would have found more in terms of Trillian, potentially even other companies. But one must understand, honorable members, is that when you start an investigation, it can take you in different directions, probably to companies that are not even related to Trillian. Because we must not for a minute believe that all of Eskom's woes are McKinsey and Trillian. I think when the head is rotten, as everybody says, the body becomes two. And then the staff would start doing, not all of them, and you've said they're great members of staff at Eskom, and they are, but there would always be the 10-15% that shouldn't be there or are rotten, and those also need to be rooted out. So that's basically what I can say in terms of, fraud, dealing with fraud in Eskom. Honorable Singh, just give me your first question again.
The first question, I think, related to Honorable Dlamini here. I just want to know, when you were engaged, he said that he asked you whether you were paid or not paid, and I was just wondering why your contract, why did you just accept termination of your contract when now you also say that you were shown the door in the past? I mean, you just terminated your contract. So I want to know if you did any work before. I think that was my first question that I asked.
Honorable Singh, I wouldn't say that we accepted it. We did write to Eskom. We did seek meetings. We did, put on the table our concerns, and we wrote them letters as well to say we should be allowed to. So we tried to a point to encourage them to do the right thing, but obviously they had other agendas.
Thank you for that, Chairperson. And lastly, I think we need to pursue the issue that was mentioned by Mr. Morgan with regard to the American company, because that's Advocate Vanara, through you, Chair, is also part of the broad investigation that we should be involved in. And maybe we need more information on that, which can be given via the Chair to Advocate Vanara. So we need to look into that as well. I don't know how long ago it was, but that's something that, from the way you put it to us, is quite a serious matter as well. Okay.
Thank you, Honorable Singh. Honorable Mganga Cabasha.
Thank you very much, Chairperson, and joining the colleagues in appreciating the report that has been tabled to us by the G9 Consulting Group. It's so unfortunate, Chairperson, that this report comes before us after we have had a number of witnesses from former executives of Eskom and current executive of Eskom at the time. They've been suspended or still at work, and the former interim board at that the interim board at that time, which is a former board now, it would have been assisted as a great deal. But in the same vein, I think it is a blessing in disguise that you are coming now after all those interactions with the witnesses that I've mentioned, because we, as the members of this portfolio committee, were able to distinguish and be able to identify certain areas that have been identified by yourselves in this report that relates to the Constitution that have been violated, a certain clause of the Constitution with regards to the state-owned entity, the Company Act of Eskom, the PFMA, the regulations that were violated and not complied with by Eskom that are issued by the National Treasury, the number of the monies that were paid without a proper contract in place, no open tender, the monies that were paid without work being done, were really identified by the members of this committee without your reports. In the sense I'm saying, maybe it's better because someone would have been that were influenced by your report. And it's clear now that as members of the legislatures and members of parliament, we are able to identify flaws that are permitted and deliberately done by our own and certain people in our own state entities who are very senior, who are entrusted with the powers that are able to, for them, given even the systems by law, by legislation, by policies, by regulations, the system that they've used to avoid what we are seeing today as Eskom, and that was and the total disregard of all those systems that are put in place by the government of the day. So I'm grateful today that you are mentioning that you are unable to conclude your investigation. For me, it's not a train smash, because if you brought in a conclusive investigation here, and that some of that information could have not been used by the law enforcement agencies that need to probe some of the people that are involved. The mere fact that we're unable to conclude that gives a room for the law enforcement agencies to tap in, as we are saying that this matter and this information is with the host, and they'll be able to perform their duties without being influenced by what has been said in this committee. They'll be able to have a room to maneuver and investigate, and surely, as we are saying, they will be able to find things as we're able, without being a law enforcement agents, as just parliament, we're able to point and connect certain dots, as it's known that our former colleague of this committee used to say that. And surely they'll be able to connect dots as people who are trained on such investigations. And it also confirms what the president of the country recently said in his SONA address, that the board members should cease from getting involved on operational and procurement processes. And I was glad when we visited Eskom this year, visited the new board and the new acting CEO of Eskom, that's the chairperson of the board, Mr. Mabuza, really indicated that as their own decision as the board, they've taken a decision that no involvement of board members on operational matters and procurement processes. Because what the president has said is exactly what is the problem at Eskom. Because if board members were not involved on procurement processes, when you submitted this report, either you submitted it to a CEO or an acting CEO at that time, or direct to the chairperson of the board, but that report would have found its way to the full board meeting to be considered, this report to be considered, and a directive would have been given to a CEO or whoever that is not being implicated here to go and investigate, or the board itself, if they have a capacity to implement or further investigate on your recommendations here, or implement what you have recommended. I see that on your conclusion, starting from page 118, you are, it's in other pages saying that, proposing that this is your preliminary findings and it should be tested and advanced by any proper structure. And if that board was not involved in these shenanigans, they would have taken that recommendation and implement it. And having said that, Chairperson, I just want finally to say, this interaction that we are having here today with this report, it confirms, I'm still convinced now, even 100% convinced, that there is no need for us to call back any witness. They came here and lie under oath. There is no need for us to waste taxpayers' money, the parliamentary resources, for us to bring back people who told us untruth and deliberately misled us under oath. And we should just leave that to the law enforcement agencies that are seized with these matters. Tina must just come to our own conclusion and at our own determination. But I'm finally really recommending that we don't re-invite anyone that was here before, whether is, what is this, the company? McKenzie. Even if it's Mackenzie who said they are prepared to pay the money, and then they are somersaulting now, they've changed, no one must be recalled. We leave it to another relevant structure that will deeper into this. And with those words, thank you very much, Chairperson.
Thank you, Honorable Kabasha. Honorable Mare.
Thank you, Chairperson. A lot was said, and I fully concur with the previous Member of Parliament. It always starts with the hidden agendas by various people to gain access to money. And normally it will follow the road of appointing the wrong CEOs and the wrong CFOs and the wrong board members. And the question always would be that those who have received money in this whole process, who did they share that with? I say in the back rooms, to put it that way. My question is actually straight. Is there anything that this portfolio committee could do to the advancement of the taxpayer of South Africa or anything else? Because in my mind, in a certain sense, the new Eskom board and the new acting CEO should actually contract you to continue with this investigation, to assist the Hawks with this whole investigation going forward. Because the Hawks themselves, hands are tied with all the other business of the day they have to do throughout South Africa. And I think they need more expert support in this regard. So that's my question to you. I know people will think I actually promote you to get a new contract, but that's not the case. The case should be we need for the whole of South Africa to see what happened here in Eskom. And this committee have another task. We must go forward with even Transnet and the NEL. So I want to hear your side of this. Thank you.
Honorable Muller, it's difficult questions to answer. We haven't come here to self-promote, although that allegation will come out. We feel that we have the skills, the expertise, we have the knowledge in respect of Trillian and McKinsey to advance this case forward to a point where people are actually arrested. The fact that people will be arrested and charged, in my honest opinion, is never in doubt. We are here, and if Eskom contracts us to assist the Hawks, and I didn't want to say it earlier, the Hawks expect that to happen and wish for that to happen, we are ready and able to serve the Eskom and to serve this country by making sure that we bring these people to book. So the short answer to your question is, we are here, and we hope that you would speak to the executives at Eskom to consider that route to follow.
Thank you very much, Honorable Mare. Honorable Luyeng.
Thank you, Chairperson. Maybe, Chair, let me join my colleagues in singing ululation songs for the presentation that we have just had that actually confirms the reality that what prompted us as this portfolio committee that we investigate the hypothetical view that is out there, that in the country there is deliberate looting of state resources, and Eskom is the champion of that. There is no contradiction, there is no contrary view that comes from all the people, even those who wanted to defend, to say what has been said out there, it's wrong. There is no fact. Safe to get a presentation from the stalwart or advocate Nsaluba and Eugene 9. You know, this splendid work that you have done, but ultimately you were undermined and someone just came from nowhere and said, stop what you are doing. That has been the practice of undermining the rule of law in the country, a new phenomenon. And that phenomenon has to come to an end. And it will only come to an end when we have people who are ethically correct in their reasoning. Reasoning in a manner that seeks to protect the rule of law and protect the gains of 1994, of our hard-earned victory of democracy. We can't allow a situation as Parliament that individuals, a small group of top echelon, a small one, a small, very few people are enriching themselves at the expense of the masses, of the poor people of this country. I mean, this is not right. It is traumatizing. We are traumatized at this committee to hear what we are hearing from all the people who are involved. And then at this particular moment, we are actually arriving, or we have arrived already, at a situation whereby we will say, no, let's sit down and consider what is it that we say Parliament must do. Now we have heard, and the country has heard for herself, as to who has been the driving force of corruption. You know, this word of corruption was actually one of those words. When one is suspecting you to be corrupt, you feel very much indebted to the democracy that we have. But now, if you say someone is corrupt, no, it's a popular name. You become popular. You are well respected because you are well connected. Because you are corrupt, you get whatever you want, no matter how. But it is good that under this administration that we have today, how I wish people out there would also follow suit and do what you are doing. What you are doing to investigate and make a contribution that seeks to identify these gaps of corruption and fraud that is practiced at higher level. An ordinary member of the community has a right to do the same. Our people must do that. We must do that as collectively as these bodies and individually as citizens of this country. Can I ask as to, when you were stopped to do this work, what method did you apply to ensure that this instruction to stop is actually played down either by yourselves or the authorities? Did you approach anyone or even a court of law? Then there is this Moodley. You have referred to a particular Moodley. What's the first name of this Moodley? Who is this Moodley? We have a lot of Moodleys and things that operate in their way in this country. Not this one. Who is this Moodley? Who is the first one? Who?
Honorable Member, I think we were talking about Ms. Viroshni. No, I think this Morley is her husband, who's linked to Albertheim, if I'm not mistaken.
The first name of the husband. I want the husband.
I don't know it.
No, you must get that name. We have a problem of people with that surname championing this corruption. And I doubt if it's not that individual, but it will come up, and we know exactly. Then the Denton's report, Chairperson, Public Protector, your outer, the Portfolio Committee, and everybody else, they have been singing the same song. That what we are doing at this committee is really the issue that is prompting this country to be ungovernable, and because people have had enough of corrupt practices when they are hungry. When we are maybe looking for water in a desert, we might be seen as if we are doing work that will not achieve the objective. But what we have done to seek the truth from the very people who have contributed in the state of affairs, and they did not come to a conclusion that says, now this is the time of the truth. They decided to lie further. But it is good that we also have information from various institutions like the G9 to say the truth and the truth alone. And that will go a long way for the betterment of this country. I think, Chairperson, there is no other way to go. There is no alternative to choose those who belong into jail must go to jail now, and those who are charged to investigate, they must continue investigating, because we are only looking at Eskom as it relates to these trillions and these small kind of engagements that are unscrupulous. There are further aspects of Eskom looting in other sectors as well. There are other monies that are going from Eskom with these boards and executives involved, with big top echelons in our business. Wabekuthiwa bekungapha emakhaya besawuthi butywala bamakhehle ngubhumpu ngumbumbumbu. Wonke umuntu uyaziqhithela. And that should, in fact, they should realize that that has come to an end. But it is good that we have organizations and institutions of yourselves who care less for what people are saying, but they remain they remain doing what is relevant for the benefit of the poor. Thank you, sir.
Thank you very much, Honorable Luyenge. Just few concerns that I would wish to raise with you, Mr. Murugan. It's the issue of Mr. Zatembe Khoza. You said he had clear intentions in stiffening the work that you wanted to do. Was he implicated in your work? If he was implicated, in which manner was he implicated? Because I take it your work was to help the utility or the SOE to open up their eyes and see the rot that is going on inside the utility. But if you say he is the one who actually made you to stop going on with the investigation, do you think, was he under pressure? Or as somebody senior or somebody who's bigger than anybody was pressurizing him to stop the work that you are doing? That's one of my questions or one of my concerns. You know, there is a trend that is coming up with everybody that comes to present in the committee, which I think needs more eyes. The subcommittees that are working at Eskom. For a company that has a contract with Eskom and not knowing if you have this contract document, who is going to receive this document? In which committees is this document going to go through? And when you come back, if there are any boxes that have been ticked and any boxes that have a sign of a concern, who to meet or who to go to. Exaro did the same when they came here. Their contracts were, yeah, they know their contracts must go through these committees, but exactly which committees are dealing with their contracts, they wouldn't know who. I think that is for a company as big as Eskom under the democratic government, openness should be the first thing that comes to their mind and be part of their policy. So if you are saying audit risk committee is one of the committees that are in at Eskom, and above all, the board members are part of the audit risk committee, I've got a feeling that it means all the work at Eskom are at risk. everything that you take to Eskom, it's at risk. If the risk committee do you think the risk committee that worked with you then needs investigation? The people that were in the in the committee then, who formed up the risk committee, audit and risk committee within Eskom, do you think that they need to be investigated? Because I take it, Eskom has got legal people that advise them. And they've got policies and procedures that they need to follow. Then can you suggest to us on the issue of legality? Mhlawumbe, advocate, you'll have to come in, even if you are not going to respond wena as a person. The people who are legally advising Eskom, and there are those scrupulous things that are happening to Eskom, what can you suggest to the committee in dealing with those people? Because I take it advocates and lawyers belong to a certain body that has got an ethical conduct that they have to follow. If they don't follow the ethical conduct that is set for them, what then can be done, or where do we feature in as the Committee of Parliament in helping those people not to do it again, or not to go forward in doing? Because I take it, if they don't follow their ethical code of conduct set to them as legal people, a criminal act maybe can be opened against them, or they should be taken away from the body of advocates, or what. I don't know that body. I've never been in the legal sphere, so I don't know. But the legal people who, what happened to such situations? Because Eskom, maybe a board member with all the qualifications a board member is needed to have, he might not be, or she might not be aware of the legal issues that they must follow. Therefore, if a legal person comes as an advisor within the company and advise otherwise, then what should be known? Because this what we have today can inform the investigation that the new board is actually ensuing within Eskom. So I just wanted you to clarify to us what can be done. Because if we continue with those people within our entities and within our government, what then? What will happen in South Africa? Those are my few concerns that I just, if you think that you are able to respond to, you can respond to them.
Madam Chair, while Senior Counsel is, obviously will put a few points on his paper in terms of your last question. Your first question is about Mr. Zatemba Khoza in terms of whether he's implicated. Obviously, he and others never gave us the opportunity to go and speak to them. But clearly from the evidence and what we see, as we say in our report, they've broken their fiduciary duties on various levels. One is the issuing and approving of these contracts which are patently illegal. And the second one and the last one is when you are informed in September that you must take action and you must open a criminal case, and it's your duty to do so. And when you don't do so, and you come to Parliament and lie that it is only a fact-finding mission and there's nothing really there, you can be charged in terms of the PFMA, even though it's not there anymore. The issue of somebody putting pressure on him, I don't have an answer to that. You know, so much changes in the world today that probably there are no people that put pressure on others anymore. Procurement policies and processes are generally followed at Eskom. And I think from what I know in the several years of being a service provider, I think it'll be unfair to say that everything at Eskom is at risk. We see good work being done. We see proper procedures and policies and process being followed. So I don't think that the business of Eskom is at risk in terms from a governance point of view. What does happen is that when you do have rogue elements in the most senior positions, whether they on the board or in the executive, those are the ones that impugn or open the risk for Eskom in terms of their conduct for whatever reasons. In terms of the ARC, the Audit and Risk Committee, when this investigation was terminated after our presentation to them, we were shocked. And the reason we were shocked is the Audit and Risk Committee, as you would know, has to be the most independent and ethical governance structure in any business and organization. The gentleman who was there at the time for a few weeks, given they were appointed as interim board members in June last year, I think it was. Many of the senior people call him Mr. Little Gupta. I don't know why they do that, but the point I'm trying to make is that he has to be so independent that even if pressure is coming on him and the committee from the chairman, they should not take a step back from doing the right thing. The standard is higher than any other committee that exists within Eskom. And the fact that, we hear that certain things that were said and what was done and the fact that they were terminated when the evidence is there, even to the Audit and Risk Committee. Leave Mr. Zatemba Khoza aside. If they are not acting, they're in contravention of every letter in the book that says that it's their duty to act. So the answer to your question is yes, they can be investigated in terms of why they themselves, the Audit and Risk Committee, why did you not take action on this report? So I hope that answers your question. And we were surprised that the chairperson of the Audit and Risk Committee, Mr. Gounden, did nothing to stop this investigation from being terminated. And that for us is a dereliction of duty there and there. Of course, we know that many of them are not there. In terms of the legality, I see senior counsel is writing profusely, so I'm not sure whether I'm going to take 10 minutes to answer that. But what I can say in terms of the issue of lawyers that work at, that come and provide service at Eskom, and this probably holds true for consultancy companies like ourselves, is that Eskom has its own legal department of professionals. Why would the board need to go and have a report provided to you by professionals reviewed by an external lawyer, be it senior counsel or others, when you could have started internally? And we say in our report, to satisfy yourself, send it to your legal department and let them say, the substance here, we are satisfied that you can act on the report. But you would send it to somebody who obviously may be writing an opinion that you want him to write or she to write, so that when you get back, you've got the piece of paper that says we cannot act on this report because it cannot be substantiated. There's no evidence, and these guys are just shooting in the dark. So that's what many government departments do, including state-owned entities. They go to lawyers or they go to companies, including audit firms, as you see, that they know will write and do work that will favor their position. And we have big audit companies falling because of that, and the same is true for lawyers. So, if you give me 2 minutes, Madam Chair, I'll just get what the council's views are.
Yeah. What I would wanted if Senior Counsel Advocate Ntsabeza, what I would want you to do in your closing remarks, you've opened the session. Therefore, in your closing remark, you sort of respond to my question. I think that would not be illegal by doing that, it will be legal because you will be closing what you have opened as the G9 representative. But for me, I just want, let me close this session by saying thank you very much for coming and make a contribution in the work of the committee, because by bringing this matter to light, you are contributing to the work of the committee, and also the whole of South Africa is benefiting out of the work that you have done and out of the contribution that you have bring to us. Thank you for your good and hard work that you are doing. We as a committee, we will be able to connect the dots. We'll be able to close the issue of Trillian now. We understand now what happened within the two companies, McKinsey and Trillian. As the chairperson of the committee has already said, it is not necessary for us to call back people who have lied to us. Open face, under oath, call them back, because really they will be repeating what they have said already. So they will not change, that will not change anything that they have said. The recommendations regarding the contravention of the PFMA and Eskom policies, as well as other legal legislations, will definitely assist the committee in its own recommendations. Action needs to be taken against people who are implicated in these matters. We also hope that what we are doing as a committee will lead to those being responsible to be held responsible for those things that they have done. I also want to single out or advocate the Senior Counsel Advocate Ntsebeza, and thank you for your good work and your contribution in the effort and in promoting and enforcing human rights. You know, this thing of human rights, people are taking it lightly. But in reality, it affects humans' lives. So if we did not have a body that looks at the human rights, a lot of lives would have been already diminished. Thank you very much in your work and on fighting corruption. In my opening remarks, I said we will listen to the investigation that you have made. We will therefore go and advise when we meet Eskom executive, the interim executive, the new board or the new interim board, the board itself. So in advising them to look at your document, they must find a way to get this document and look at it and see if it won't make their work simpler to go forward and in their own investigations. You know, this report that you have given us, it also helps the committee not to call each and every member that was involved in the transactions of Trillian and McKinsey. It rounded up that work that we were supposed to be doing, because we might have had a job of calling maybe 10 members or 20 members that were involved in the transactions. But now, because we've got this document in front of us, we are able to know what happened within the transaction. Thank you very much, and thank you, committee members, for the time you have taken. As usual, I know you are dedicated members of this Committee of Public Enterprises. There are a few announcements that I would want to do, but I want to give over to the Senior Counsel Advocate Ntsebeza to just round up his work with maybe few comments.
Thank you, Madam Chair. It's really an honor and a privilege to be allowed in this very unconventional way to to make my voice heard at your committee, and I now feel very relieved, especially when I see that Mr. Swartz is is smiling now. Is no longer going to be saddened by the fact that when he was clear in his cross-examination of Mr. Singh that he was getting him to a place only to be punctured by Mr. Singh saying, that report was withdrawn. Now he knows what the truth is. Which brings me to your question, Madam Chair. I think this portfolio committee has got the power and the authority when once it gets seized with some information that impacts on whether or not in the conduct of its work, certain professions or certain professionals in the pursuit of their professions have acted in a manner that is unethical, even in terms of their professions. The question that I've asked myself as I got to know about what was going on in Eskom, and as Mr. Murugan has indicated, we have been involved in several, not several, the Converge investigation. Again, we were met with the same modus operandi. We would not get cooperation from the top executives. They wouldn't allow us to meet the witnesses who were critical for us to conduct the investigations. It was amazing how an amount of money running into millions would be paid upfront without the contractor, so-called contractor company, had done a stitch of work. And in relation thereto, I've always wondered, because one gets to know that these state-owned enterprises, Transnet, Eskom, all of them, they employ huge companies. They have got in-house counsel. They employ also large companies. I won't mention names, but huge companies with years and years of experience. And you ask yourself, how are these legal firms advising their clients if their clients are found to be routinely breaking the law in the manner in which the G9 report has revealed? One asks the question, is it not time that we as lawyers must answer as to how certain things happen when we are there and we're supposed to be the custodians of the law or advising our clients? Reports like these, where it is clear that there was a violation of the legislation, the regulations, the Constitution, where were the legal advisors? And what were the legal advisors advising them? When you get to be told that there was an opinion given by an esteemed senior advocate to the fact that payment can be made and the people who were involved in an investigation which sought to attribute blame to the manner in which executives in Eskom were conducting themselves. Now, I'm not the one who must say what the committee should do. But it is very clear to me that in connecting the dots, the committee must be able to say, if it is so, and you have had testimony here, that G9, who had conducted the investigation and had produced this report, were never conducted by way of giving a basis for the opinion that was eventually given. When it is clear from what this report says that in Eskom, the head of legal services had said certain compliances have to be followed in order for monies to be paid, and that did not happen. What is our duty as lawyers when there is conduct which is unethical? If we are party to that, to what extent can it be said that we are complicit as professionals? You may or may not know that I'm currently seized with an investigation into the conduct of chartered accountants who were employed by a particular audit firm. And the question is, to what degree were they acting in line with their ethical code of conduct of the Institute of Chartered Accountants? So there is a whole range of professionals who now must be looked at. We cannot always take the attitude that we are beyond reach. If there is conduct that calls into question how we conducted ourselves when we deal with issues that affect the nation, and there can be nothing that has damaged this nation as to hear evidence day in and out of how monies have been siphoned to illegitimate and channeled through illegitimate channels to illegitimate purposes and ends. How do these things happen when the professionals are there? And that is what I believe this committee has the power either to investigate or to refer conduct by professionals involved in this committee's investigations to the relevant bodies. If it is lawyers, there are law societies. If it is advocates, there's the council, General Council of the Bar. If it is chartered accountants, there is SAICA. And if it is audit firms, there is the independent regulatory body of accountants. That needs everyone in our constitutional democracy needs to be held to account. The simplest explanation of what the rule of law means is that no one, but no one, is above the law. That is what I would personally recommend. And I thank you for the indulgence.
Thank you very much, Advocate, and thank you to everybody. Honorable members, tomorrow we are seeing the former CGC of Eskom that is still, he is still group executive who is suspended, but we are going to see him tomorrow. And Mr. Dumieni, we do not have a confirmed letter yet that say Ms. Mieni is coming, but we are expecting to see her tomorrow. Yeah. Thank you very much. The meeting stands adjourned. No, same venue, yes, same venue. And same time, 9:30. All of them are coming tomorrow morning.